Good afternoon and welcome. Before we begin today's meeting, some of the members of the task force need to be sworn into their new terms. So if the clerk of the board's representative, Ms. Licavoli, could approach the microphone and we can start with that portion of tonight's proceedings.
Okay. Good afternoon, Madeline Licavoli, Deputy Clerk, Clerk of the Board's Office. Would the members who are going to be sworn in please stand? Okay. You're going to repeat the oath after me, but I'm going to say I, and then if you'll state your names as we go along. So I. State your name.
Richard Nee.
Do solemnly swear. That I will support and defend. The Constitution of the United States. And the Constitution of the State of California. Against all enemies, foreign and domestic. That I will bear true faith and allegiance. To the Constitution of the United States. And the Constitution of the State of California. That I take this obligation freely. Without mental reservation or purpose of evasion. And that I will well and faithfully. Discharge the duties. About which I am about to enter. And during such time. As I hold the office of. Member of the Sunshine Ordinance Task Force. Of the City and County of San Francisco. Congratulations.
Thank you.
Mm-hmm.
Thank all of you, and thank all of you for coming today. We'd like to welcome you. This is a regular meeting of the Sunshine Ordinance Task Force, called for Tuesday, May 25th, 2010 at 4 p.m. and beginning at 4:18 p.m. Roll call, please.
Yes, Mr. Chair. Member Snyder.
Present. Sorry.
Snyder present. Member Nee.
Here.
Nee present. Member Cawthon. Cawthon present. Member Manny. Manny excused. Member Washburn. Washburn excused. Member Caneva.
Here.
Caneva present. Member Goldman. Goldman excused. Member Wolf. Wolf excused. Member Chan. Chan excused. Member Johnson.
Here.
Johnson present. Member Williams.
Present.
Williams present. Mr. Chair, we have a quorum.
Thank you. Are there any changes to today's agenda?
I'm just
Member
asking if the committee reports, which are at the very end of the agenda, before the after the consideration of the amendments, I'm asking if we could take them in their usual place, which is after the hearings. And the reason for that is that there were no committee reports last month because we lost the quorum, and our committees are doing really important work, and I'm going to make the report for the Education and Outreach Committee, and we do have something that we want to move forward. So the problem is when we get to the amendments, they tend to take an awful long time, and sometimes we lose the quorum. So I would respectfully ask if we could do the committee reports before the amendments.
Without objection?
Thank you.
Okay. There has been one complaint withdrawn. That is item numbers 18 and 19 on your agenda. That's complaint number 10021, a complaint filed by Anonymous against the Recreation and Park Department. So those items 18 and 19 are withdrawn. Also, we could probably get this out of the way right now. On items numbers 12 and 13, this is complaint number 10010, filed by Paula Datesh against the Arts Commission. The complainant has reported that she is in the hospital and wishes to have this item continued. Is the respondent present?
I am present.
Okay. Do you have any objection, sir?
No objection to the continuation, but I do see that the city attorney wrote to the task force stating that, in their opinion, that the task force doesn't have jurisdiction in this matter because it was It's the exact same complaint that she filed 3 months ago that was dismissed by the complaint committee.
Okay.
We don't understand why the complaint committee boosted this one up to you at this point.
If it comes back before us, we can adjudicate jurisdiction at that time, sir.
Okay. But for now, you're continuing it?
For now, we'll continue.
Okay, I'm grateful to you.
Okay.
Thank you.
Thank you. Without objection? Okay, items 12 and 13, complaint number 10010 is continued to our next meeting, which is June 22nd. Any other agenda changes? Okay. Seeing none, Mr. Clerk, would you call the first item, please?
Yes, Mr. Chair. The first item is the approval of March 23rd, 2010 meeting minutes.
Okay, is there a motion on the minutes of March 23rd, 2010?
I move that we accept the minutes as written.
Second.
Moved and seconded. Brief pause. Moved and seconded. Is there discussion? Okay. Is there any public comment on the minutes of March 23rd, 2010? Speakers will have 3 minutes each. Thank you.
Members of the task force, in addition to the minutes of this that you're considering right now, I would like to point out to the task force, if you visit your own website, the last half of last year, there are no minutes for any of the meetings which were held except one. And the first half of this year, some of the committee meetings have been held in each of the months, and yet there are only one set of minutes. So either you're going to keep it up, or I would submit you take them down, because basically what you have up there is not representative of the finalized minutes, and in fact gives a very bad example if you're going to take anybody to task for not keeping minutes in their particular commission or department or whatever. It doesn't look very good if they can simply point to your website and see that you have failed for almost a year now to post minutes of the task force meetings.
Thank you. Is there further public comment on the minutes?
I'm not sure I'm addressing the minutes issue at the right time, but I had a question whether the task force members who were at the meeting have to be the ones who approve the minutes, because you now have, I'm seeing what, 1, 2, 3, 4, 5, 6, 7 members here, 2 of whom were not at the March meeting, nor any of the other meetings that were held prior to today. And I'm not sure whether under the Roberts rules or whatever that it would be appropriate for them to vote yay or nay on minutes, particularly as the minutes come up, which should involve the deliberations of the task force and the changes that were made to the draft amendment when they were not present, or at least in the position to be present for those meetings.
Thank you. Is there further public comment on the minutes? Seeing none, public comment is closed. Mr. Threed, I'm wondering if you could give us some guidance on the point that Mr. Grossman has raised?
Through the chair, Jerry Threed for the City Attorney's Office. Chair Need, the members of the task force serve in a representative capacity, so each member, when a new person comes to take their seat, serves in the same capacity as their predecessor, so they can sit and vote on any item that's on the agenda, whether they were at the last one or not. It may be advisable that if they're going to make a vote, that they review the tapes so that they can understand what happened, but they are entitled to vote.
Thank you. Further discussion among the task force?
Chair Newt,
Member
I
Cawthon.
just wanted to say one thing. This happens from time to time at the library CAC, which I chair. And I showed them something that recently appeared in the Planning Commission packet, which was a notice that everybody had to vote on the minutes whether they were at the meeting or not.
Okay. Member Williams, did you have?
Yes, I agree with the person that came to the mic. If they're not fully aware and got the package in time, it's usually we don't get our package in time. I don't see how they can vote on the minutes.
Okay, further comment? Is there a motion for continuance on this item?
I make a motion that we continue voting on the minutes.
Is there a second? There is no second. The motion to continue dies. We have the roll call, please.
On the motion, Member Snyder? Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Caneva?
Aye.
Caneva, aye. Member Wolf?
Please repeat the motion.
Approval of the minutes of
Approval of the minutes of March 23rd.
March 23rd.
No.
Wolf, no. Member Johnson? Aye. Johnson, aye. Member Williams? No. Williams, no. Mr. Chair, we have 4 ayes and 2 noes.
You, make that 5 ayes and 2 noes.
Member Nee?
Aye. Okay. What I would suggest then is that we schedule the minutes of March 23rd for our next meeting. And those of us who did not have a chance to review them or who were not at that particular meeting, please do so. Review the tapes by our next meeting on June 22nd. Mr. Clerk, could you call the next item, please?
The next item is approval of April 27, 2010 meeting minutes.
I move that we approve the minutes.
Is there a second?
I second.
Moved and seconded. Discussion? Member Cawthon?
I saw a couple of things. Jerry Threet's name was spelled wrong on page 27 in paragraph 2 of number 17. And then on pages 21 and 22 and 24, 25, 26, the word motioned was used instead of the word moved. So-and-so motioned that the meeting adjourn, so I would just suggest that the word motion be changed to read moved, and I will submit where those things occurred.
Okay. Further discussion? Is there public, Mr. Threet?
Yes, Chair. Can you, I wasn't here at this meeting, but I just note in item 6 in the minutes, the hearing was on whether the mayor's office had complied with the order of determination rather than the city attorney's office.
Noted. Thank you. Further discussion? Is there public comment on the minutes?
This, I think, may be a little different. I'm looking for my notes of the special meetings that took place after the March meeting and before April 27th. I believe there were 2 or 3 in between special meetings. So if my memory is correct, these minutes leapfrog 3 meetings. 2 or 3 meetings. So, again, I'm not sure that it's appropriate when actions are taken at subsequent meetings that may involve actions that were taken at prior meetings. And since the special meetings all involved changes to the draft ordinance, amendment to the ordinance, I'm just wondering if it's appropriate that leapfrogging should be considered appropriate at this time. I think it would be better, as I've been saying for the last 3 or 4 meetings, that we had minutes of those special meetings, not for this reason, but more appropriately to find out what happened in terms of the changes to the draft that was originally approved in, I believe, early March. Thank you.
Thank you. Further public comment? Seeing none, public comment is closed. Mr. Rustin, I would direct you that at our next regular meeting, you have some minutes of special meetings here, I noticed, toward the back of the packet. Those, I believe, should be brought up for approval, should they not?
I do not want to present it for approval before I finish the prime special meetings, Mr. Chair.
Well, I don't think they should be taken out. I think approval of minutes should be taken in sequence, whether they're regular or special. I don't think that's, I don't think there should be any kind of a distinction made between the two. They should be in chronological order, regular and special.
I'll have it in the next month's package.
Thank you. Is there further discussion on the minutes? Okay, the motion is to approve the minutes. Roll call, please.
On the motion, Member Snyder. Snyder, aye. Member Cawthon. Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Caneva.
Aye.
Caneva, aye. Member Wolf.
No.
Wolf, no. Member Johnson.
Aye.
Johnson, aye. Member Williams. Williams, no. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 6 ayes and 2 noes.
Thank you. Mr. Clerk, could you call the next item, please?
The third item is hearing to review new information that could result in the reopening of file number 09075, Brett Starr against the City Attorney's Office.
Okay, is Ms. Starr present? All right. The chair is going to suggest that this item be removed from the agenda. Ms. Starr approached the chair at the end of the last special meeting, a week ago today, said she would like reconsideration. She had new evidence to present to us. I asked her if she could get it to the clerk, Mr. Rustin, by last Thursday. She said she would. She has not done that. As near as I can tell, and Mr. Rustin will correct me if I'm wrong, that information, that additional information, has not been presented to us yet. Is that correct?
That is correct, Mr. Chair.
In that case, without objection, item number 3 will be removed from today's agenda. Mr. Clerk, could you call the next item, please?
Item number 4 is determination of jurisdiction on complaint filed by Juan Leander against the Department of Public Health for allegedly withholding information.
Okay. Is there a motion to accept jurisdiction?
I move that we find jurisdiction on this matter.
Is there a second? Okay. Has jurisdiction been contested?
Don't. We had at the complaint meeting. They came before. They did not contest jurisdiction. They tried to prevent backs, and we didn't get any actual contestation of jurisdiction. No.
Okay. Thank you. Is there a motion? Is there a public comment on the question of jurisdiction? Seeing none, public comment is closed. Is there further discussion by the task force on jurisdiction? Roll call, please.
On the motion, Member Snyder. Aye. Snyder, aye. Member Cawthon. Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Caneva.
Aye.
Caneva, aye. Member Wolf.
Aye.
Wolf, aye. Member Johnson.
Aye.
Johnson, aye. Member Chan.
Aye.
Chan, aye. Member Nee.
Aye.
Sorry, Member Williams.
Aye.
Williams, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 9 ayes.
Okay. That takes us to the substance of this complaint. Item number 5 is the complainant present, Mr. DeAnda. Is there any... Okay. Has Mr. DeAnda, Mr. Clerk, has Mr. DeAnda indicated that he would not be here?
I sent him an email reminding him of the meeting, but he hasn't responded.
Okay. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Is there anybody here to present facts and evidence in support of the respondent? Okay. The chair will entertain a motion to table this item.
I move we
That we
table.
table it.
I second it.
Moved and seconded. Do motions to table carry discussion? Okay, is there any discussion on the motion to table? Seeing none. Is there any public comment on the motion to table complaint items 4 and 5, or item 5, complaint number 10011? Seeing none, public comment is closed on the motion to table. Roll call, please.
On the motion, Member Snyder. Snyder, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Knebber.
Aye.
Knebber, aye. Member Wolf.
Aye.
Wolf, aye. Member Chan.
Aye.
Chan, aye. Member Johnson. Johnson, aye. Member Williams. Williams, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 9 ayes.
Thank you. Mr. Clerk, could you call the next item, please?
Item number 6 is determination of jurisdiction on complaint filed by Nick Pascarello against the Bay Area Video Coalition and forwarded to the Department of Technology for resolution under Chapter 12L of the Administrative Code.
Okay, is there a motion on jurisdiction?
I move we find jurisdiction.
Is there a second?
Second.
Moved and seconded to find jurisdiction. Discussion? Is there public comment on the motion to find jurisdiction?
Pardon me, I'm with BAVAC. Is this an appropriate time for me to address the issue of jurisdiction, or is there another
Were
opportunity?
you going to contest it?
Yes.
Okay. The motion then will be suspended. However, since you wish to protest jurisdiction, is the complainant here, Mr. Pasquariello? Please approach, sir. We are discussing jurisdiction of this matter only, not the substance of the case. So you have 5 minutes to explain why you believe this matter is within the jurisdiction of the task force.
I thank you for entertaining this motion thus far. I'm here to enforce a provision of the contract between Bay Area Video Coalition and the City and County of San Francisco dated August 20th, 2009 under Article 12, Disclosure of Information and Documents, Section 12.2, Sunshine Ordinance. It says, grantee acknowledges and agrees that this agreement and the application documents that are subject to Section 67.24 paren E closed paren of the San Francisco Administrative Code, which provides that contracts, including this agreement, comma, grantees' bids, comma, responses to requests for proposals, paren uppercase RFPS, close paren, and all other records of communications between city and persons or entities seeking contracts shall be open to inspection immediately after a contract has been awarded. That is the reason I've filed this complaint with this body. BAVAC has repeatedly refused to release public documents to me, as has the Department of Technology. As recently as a couple of months ago, I made a request of the Department of Technology for a complete copy of the budget for BAVAC. They had previously sent me 1 or 2 pages of this document, and they refused to, by virtue of not responding to my second request, refused to release the other approximately 50 pages of the BAVAC budget. So that's why I'm here.
Thank you.
I don't. You're welcome.
Respondent, please. You have 5 minutes.
Sure. I'm not sure if I'm the proper party or if the city also would address this, but my name's Chrisanna Hodges, and I represent BAVAC. BAVAC's contract with the city does bring it within the scope of what this task force does in two ways. One was that acknowledgement that you just heard. That acknowledgement, however, was BAVAC's contractual acknowledgement that all of these documents, that the contract that it has with the city, that its request for proposal, are made public by the city and available for inspection, which, from what I understand, is true. I know of, I wasn't party to the request around the budget. I know of no one at BAVAC who was party to the request that was just mentioned here. All I know is this letter that we have that we received through an unregistered fax that asked for all of these documents, which are not really within the kinds of records that BAVAC keeps in a way that it can easily hand over. But I understand are very much within the kind of records that the city keeps. The other way in which BAVAC comes within 12L is that BAVAC makes some of its board member meetings open to the public and has some other kinds of documents that are open under 12L. And I'm here because BAVAC believes in the task force and what you guys are doing and in being transparent. But we're having a problem where we're receiving these faxes that are coming from an unregistered fax machine. They don't include a return fax number or any meaningful way to communicate with Mr. Pasquarelli once we realize that we have the faxes, because they're initially flagged as spam because they come through unregistered. And while I appreciate having a P.O. box, receiving a fax sort of suggests that we would be able to fax back in kind, because the documents that he's requesting, I believe, are available on the Department of Technology website. I very much want to respond to any of Mr. Pasquarelli's requests to the extent they fall within the purview of what we do, and to the extent BAVAC has that information and needs to give it to him. It is not our intention to withhold it in any way. But these requests are not being delivered to us in a way that make it easy or seem to even call for a response. Instead, they seem to be delivered in a way that tee them up so that they can come before the task force. And quite candidly, there's nothing here in this request that really pulls BAVAC within the reach of the task force. To the extent that 12L applies here, BAVAC is in full compliance and is.
Excuse me, Ms. Hodges, you're arguing merits now.
Pardon me.
We're simply
To the
determining
issue of
jurisdiction.
Yes. Then to the issue of jurisdiction, just to be clear as to what's separate from the merits, the provisions of 12L that do affect BAVAC don't speak to this request. And this request has not been processed such that we could have even dealt with this. I believe there was a committee. The Department of Technology would have received this request. I'm just not sure why BAVAC is here now. And that tells me that perhaps there might be a jurisdictional problem.
Thank you. The matter is back with the task force. Okay. Well, no, they're not actually. The complaint is against the ABC. Okay. Is there public comment on the jurisdiction issue?
Hi, I'll try to be as brief as possible, but I think there's one or two things that I could say that might be helpful. My name is Tracy Rosenberg. I'm the Executive Director of Media Alliance. We are a 501c3 media advocacy group that's been active in the Bay Area for many years, and we've been interested in the fate of public access in San Francisco. What I can testify to here is that Mr. Pasquarelli, in fact, requested the operating budget for the first 3 years of the Bay Area Video Coalition contract, which is a contract with the city to provide public access services for the city, and he is a user and a participant in public access. After many contacts with the city, he received, as he stated, 2 or 3 pages of a 53-page document, a 53-page operational budget that was submitted by BAVAC to the Department of Technology. He then, I assume, proceeded to ask for this document from BAVAC under the presupposition that BAVAC had in fact prepared and submitted the document and therefore could make it available to him. That also was not successful, and that is, I believe, why he is in front of the commission. I do think that it is not appropriate to take an individual who is not a business and does not have a personal fax number and basically throw them back and forth between the city and BAVAC on a jurisdictional, I would say, technicality, basically saying you cannot get the information from point A, you cannot get the information from point B. As an individual, he is entitled to review that document, and I think it is within the purview of this committee to establish that he can receive it from one of the 2 sources he has already asked unsuccessfully. Thanks.
Thank you. Is there further public comment on the jurisdictional question?
Yeah, my name is Steve Zeltzer. I'm a member of BAVAC and a producer of the Labor Video Project in San Francisco. And I support your commission taking charge of this complaint. Frankly, we were very concerned about the transfer of the community access station to BAVAC because of this very problem. BAVAC says they don't have money, that they need more money from the city, yet they're spending money for a lawyer to come here and tell you that they can't send out documents that have been requested by a user of BAVAC about what's going on there. I, as well, am interested in these documents. What is the project budget of BAVAC? How much money do they expect to get? How much money are they getting? And these documents should be provided to the public because they're getting public funds. So I think this is an appropriate place to determine this, and I hope that you make that determination. Thank you.
Thank you. Is there further public comment on the question of jurisdiction?
Yes, good evening. My name is Julian Lagos. I am a producer, former producer at Public Access Television. I've been a public access producer since 1992. I believe Mr. Pasquarello has jurisdiction here with his complaint based on the fact that I myself have asked for, I've had questions and asked for documentation as to how BAVAC runs its operations. I personally witnessed last December, during the holidays, after they closed the station on Market Street, giving away furniture and items from the station when they shut down the station to third parties. I've asked BAVAC and the city to please tell me how much was given away and who the parties were given away to. They refused to disclose that type of information. So I believe Mr. Pasquarello's complaint does have jurisdiction. The public has the right to know where their money is being spent and how public access television is being operated. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. We do have a question from Member Snyder. Given that jurisdiction was not initially contested and could be dispositive, would it be appropriate to continue so we can consider the jurisdiction question properly? Mr. Threet, perhaps you have a comment on that?
Chair Kenning, through the chair, Jerry Threet with the City Attorney's Office. I have a couple of comments on this issue. One is that the task force on rules call for any materials or communications regarding the complaints from the parties to be provided to the task force administrator at least 5 days before the hearing. Those rules are sent to both parties when the complaint goes out. BAVAC had that, yet the letter contesting jurisdiction came after that 5 days was done and after this memo was completed. That being said, jurisdiction is a very basic core issue, and if there's not jurisdiction, then it should be something adjudicated by the task force. So It would, I believe, be appropriate if the task force wishes to continue this matter to more fully consider those materials. And on the materials themselves, the issue of jurisdiction is a complicated one in this case. The contract itself provides that these documents that have been sought by the complainant shall be provided under Section 67.24 of the Sunshine Ordinance. It does not more generally provide that that BAVAC is subject to the jurisdiction of this committee. So it could be read one of two ways. The contract provision is unclear on this. It could be read that since the documents are subject to disclosure under the Sunshine Ordinance, then this task force necessarily has jurisdiction to adjudicate that matter. It could also be read as BAVAC argues that the documents have to be disclosed, but the disclosure should occur from the Department of Telecommunications, or Technology, I think it is called now. So it's something that I think the task force needs to grapple with. It's not a clear issue, and there's the separate issue of whether there's jurisdiction under Administrative Code 12L. So if you just take that contract provision out, and they were asking, the complainant was asking for information from this nonprofit, then the jurisdiction question would be, is there jurisdiction under 12L? And under that section, when you're asking for documents outside of the ones listed there, you have to go through a mediation process with the department that supervises the contract. It's unclear whether that happened in this case. So I think there's some unanswered questions here.
Okay, well, I would think that the latter question would actually be a matter of the merits of the case rather than the question of jurisdiction.
Traditionally, the task force has looked at this often through the guidance of Vice Chair Craven Green as a jurisdiction issue, because if there hadn't been mediation, the task force has traditionally took the position that you could not reach the question of whether there was compliance with turning over the documents, because the complainant in that case would not have done what's necessary to reach that question.
Okay. Well, in that case, I think it would be appropriate and relevant to, Mr. Pasquarello, could you approach the microphone, please? Let's just take this on a step-by-step basis. First question. You requested certain documents from BAVC, correct? Yes or no?
I don't have all my records with me. I requested this. Yes, I did request. I requested that they comply with the section that I read to you before.
Okay. You requested certain records from BAVC, correct?
Yes, I did.
Okay. Second,
Excuse me for interrupting. That section that I read to you before, that was precisely what I quoted in my request to BAVAC some months ago. That is exactly what I did.
Second question. Did BAVAC provide those records?
No.
Third question. Did you then go to the Department of Technology and request assistance from the Department of Technology in obtaining those records from BAVAC?
No, but to get the chronology, after that, no. Chronologically speaking, I did not.
Okay, you've not done that yet?
No, but I did it prior to this later request for the documents.
No, we're talking about the set of documents, the latest request.
I understand.
You have not been to the Department of Technology for... Okay. Be seated, please. Is there further public discussion on the jurisdiction question? Member Wolf.
I'm just wondering, and maybe DCA 3 can answer the question, with regards to nonprofits or other entities that are receiving city funds, what is the application of Sunshine then?
Through the chair, Member Wolf, the Sunshine Ordinance generally does not apply to nonprofits. There is Administrative Code 12L that applies to nonprofits and provides for limited disclosures of certain documents that are enumerated therein.
Thank you.
And
Member Knebber?
And it also stipulates that they have to receive a certain threshold of money from $250,000
$250,000 at least. Further discussion?
Move to continue.
There's a motion to continue. Is there a second?
Second.
Moved and seconded. Discussion? Member Kneber?
For what purpose? Do we want to put it down to complaint committee to talk about it, or, I mean, we have the full task force here to talk about jurisdiction. So,
I'm just actually going by council's suggestion that it's a complex issue and that it should be possibly consider further other documents. I don't know specifically what, but I think
I think, I mean, in the past, as our city attorney has expressed, we have, and I'm not saying we have to, I'm just saying we have followed the procedure and the idea that if they hadn't gone through the mediation of the city department, then we've asked them to do that, and then if that doesn't go through, they can place the complaint. I think that, I mean, we can continue, but I don't see why, and I don't see what documents are going to be brought up. We can get the information now and talk to them and decide.
Member Williams and then Member Washburn.
I have a great concern. Attorney Treat has been out, but I have called him concerning 12L, and I haven't got a response from him. And I called the city attorney. This really seems to be complex. I even asked Attorney Craven for what she asked, and she says, you know, you're going into a gray area. You need to call the city attorney's office. And with these CBOs out here, nonprofits, getting all this money, we need to really rethink this. I'm really concerned about it because it's been brought to my attention, and I've been to the city attorney, and I know Mr. Treat has been out, but I've called your office and left you a message. And nobody seems to give me an answer when we get up under 12L. They say, well, it's a gray area, and you have to go through certain. Why is it a gray area? If they receive $250,000 and they're getting money from taxpayers, they deserve it. If they exhaust the means, I don't know if he's gone through the correct procedures, but he deserves an answer, and I think he's in the right place. So we need to really get together and see about 12L, because I'm concerned about 12L being so where we can't get involved in it.
Member Washburn?
There are a lot of people here today concerned about this issue, and we also have a representative from the Department of Technology. And while he's here, couldn't we talk to him or let him speak to this?
If you have a specific question for him, you're certainly welcome to ask it. Mr. Threed, I believe you had a comment?
Yes, Chair Kennedy. I wanted to clarify. It sounds from the discussion like the understanding taken away from my comments was that there should be a delay. I was simply opining that it's appropriate to have a delay if the task force wishes to. I don't have an opinion on whether the task force should delay this matter. I believe all the arguments are before the task force, and you could, if you choose to, grapple with the issues and resolve them tonight. And Member Williams, I want to apologize for not returning your phone call. My understanding from Deputy City Attorney Frank Brass is that he had discussed the issue with you, so I thought it had been handled.
Member Kneber.
I reiterating what I said before. I do think that we have the information to get through here, and I do. 12L is something that we keep running into, but I do think the issue is always the same. I don't think it's that complex. There is a specific procedure laid down on how nonprofits can be how complaints can be presented against nonprofits, and you have to go through a certain procedure that's laid out in the statute. So I think that we can talk about it now. I would be against continuing. I think that we should find out now.
Member Chan?
I believe previously we've taken this 12L and we just not continue, but we took jurisdiction on it. So I don't see why not we can't do it now.
Member Knebber.
Well, I think the issue in this case again is that we find jurisdiction when they've gone through the proper channels, and I don't. And this, and by, and again, we can ask more questions, but I think in this case they haven't exhausted the proper channels where they've actually gone and sought mediation from the city department, and that it specifically says that we can find jurisdiction after that process is, or it comes within our purview after that process has taken place, and if it hasn't taken place, I don't think it's ours to deal with.
Member Wolf.
So I'm a little confused now. Is the recommendation from the complaint committee to find jurisdiction or not to
Well,
find jurisdiction?
Mr. Wolf, right now the question before us is whether to continue the jurisdiction question. Not to vote yes or no on it, but to continue.
I understand that, but mine is a point of information because it will determine whether I withdraw this motion or not.
Well,
Member Knebber.
First of all, we don't have the entire complaint committee here. I'm the only one here from that committee, and I wouldn't speak for the whole committee. But my opinion is that it's not from the information I've heard, I would vote against jurisdiction at this point, personally.
But my question was, what was the recommendation from the complaint committee?
It didn't go before the committee.
It didn't go before the committee. Okay.
Member Cawthon.
I just wanted to reiterate what was it, Member Wolf, or whoever said that. I think it was Mr. Chan, that we should grapple with this tonight. I mean, it seems like there's some issues here that we need to get to the bottom of. We've got somebody here from BAVAC. We've got somebody here from DEDIS, I believe. So and we've got Mr. Pasquarella. So let's address this issue.
Okay, further discussion.
Continuance.
Further discussion. On the motion to continue, roll call, please.
On the motion to continue, Member Snyder? Nay. Snyder, no. Member Cawthon?
No.
Cawthon, no. Member Washburn?
No.
Washburn, no. Member Knebber? No. Knebber, no. Member Wolf? Aye. Wolf, aye. Member Chan?
No.
Chan, no. Member Johnson? No. Johnson, no. Member Williams? Williams, aye. Member Nee?
No.
Mr. Chair, we have 6 noes and 2 ayes.
There are 9 of us here.
Right.
Who, it should be
It should be 7 noes, Mr. Chair.
Thank you. That takes us back to the main motion of whether there is jurisdiction. Is there further discussion on that question? Roll call, please.
On motion to find jurisdiction, Member Snyder?
Yes.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? No. Knebber, no. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Williams? Williams, aye. Member Nee?
No.
Me, no. Mr. Chair, we have 7 ayes and 2 noes.
That takes us to the merits then. Mr. Pasquarella, would you please approach? Sir, we are now at the point where we're discussing the actual merits of your case. So you have 5 minutes, please.
Well, I'm not sure there's much I can add. As you may recall, I was before this body approximately 3 months ago. The basis of the prior complaint was BAVAC's refusal to respond in any way to a certified letter that I mailed to them requesting their policies about scanning driver's licenses into their computer. That was my prior complaint. BAVAC has a history of not responding to producers or the public. The merits of the case. I mean, I read the contract. Frankly, I'm a little bit confused as to whether the 12L is still an option here. Is that? I mean, I'm supposed to be talking. You can't respond to that question, could you?
At the moment, no. Please continue.
Okay. I have a copy, I think, of 12L here, and it's very disappointing because it says at the end, any determination shall be non-binding on the parties, on the party to which I'm complaining about. I can just reiterate what other people have said. This is a body receiving public money, taxpayer money. We all have a right to know how they're spending that money. It's so straightforward, I don't know how it could be any more straightforward. So I'm just requesting to know how they're spending the money. I really don't know what else I can add to that.
Thank you. Is there anybody here to present facts and evidence in support of the complainant?
Yes, Steve Zeltzer.
Mr. That was during the previous item.
Yeah.
I'm sorry. Please continue. You have 3 minutes.
Yeah, I support the complaint on the basis that I've asked for material. I have not faxed from a registered fax machine and that kind of thing, but I've asked for material, and there's a reticence of the Bay Area Video Coalition to provide material, which was done when it was under the operation of the CTC. They're required to support the material. They get hundreds of thousands of dollars with city grants, and they should be subject to the rules that other contractors with the City of San Francisco are. And this is especially the case since there's been a rapid decline in usership at the station. There were 130 producers. Now there are only 50 producers. So less people are actually using the facilities. So the question is, where is the money going? We have a right to know. It's our tax dollars. And I believe in community access, and I think we need to know the amount of money that's going and what it's going for. So I support the complainant. Thank you.
Thank you. Is there any further facts and evidence in support of the complainant?
Thank you, Commissioners, again. In support of the complainant, I myself, as I stated earlier, witnessed the giveaway of numerous items from the station when it was closed last December. I believe the public has the right to know what was given away between December 21st and December 23rd, 2009, when I personally witnessed a giveaway to a number of parties. I have photographs of that particular, of those 2 days that I was there that I don't have with me today, but I'd be more than happy to share them with you if you allow me to an extension of time to submit it into the record. That was posted on IndieBay back in December of 2009. And I believe the public has the right to know where their money is being spent or being given away by this nonprofit who, by the way, came to the city back in January of this year asking for a $375,000 grant, which they were denied by the Board of Supervisors. So you have to wonder, why are they asking for money when they're giving it away? And as a tax-paying resident, I'd like to know how the money's being spent. Also, as a former producer, I'd like to know where my driver's license information is being sent to or contracted out to. As somebody who's been a victim of personal identity theft, especially in the last 60 days where I've had my computers hacked and passwords stolen and had an internet connection shut down in the past 7 days, I'd like to know if BAVAC has any connection between my personal information and a personal identity theft that I've experienced in the past 60 days. So I believe that the complaint is worthy of your consideration, and I hope that you give it serious consideration tonight. Thank you.
Thank you. Is there anybody else to present facts and evidence in support of the complainant?
Yes. Very briefly, I think it's fair to say that the reason Mr. Pasquarelli keeps appearing in front of this commission is that he has concerns about how BAVAC is carrying out the contract. He may be right with those concerns, and he may be wrong. I think his concerns have some merit, but that's really totally beside the point. The reason he wants these documents is in order to ascertain for himself how the money is being spent and if the services are being provided in compliance with the contract the city has signed. That is his right. He asked for the documents from the Department of Technology and did not receive them. He asked for the documents from the contractor, the Bay Area Video Coalition, and he did not receive them. At this point, he has no other entities to ask. So while I do not in any way want to make aspersions about the complexity of the 12L process, I want you to understand that from his point of view, he has already asked the only two entities who can provide him with the document, and they have both failed to do so. That's why he's standing here in front of you. In terms of 12L, whose purpose is, of course, to help the public ascertain whether vendors are performing their contract in compliance with the terms of the city. That's the purpose of 12L. BAVAC's compliance has some issues. For example, as an advocate, I very much wanted to go to the board of directors of the Bay Area Video Coalition and say my piece regarding their plans for public access in San Francisco, which I don't personally agree with. That contract was awarded in August of 2009. The first opportunity that I will be given to address their board of directors in an open board meeting is August 23rd, 2010. I am not saying that is not within the letter of 12L. I am saying it is not within the spirit of 12L. So I do think it is appropriate to take 12L seriously, and I think it is appropriate for this commission to look at how Mr. Pasquarelli's concerns can honestly be addressed by the city of San Francisco. I think they should be.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Mr. Pasquarello, you've already spoken. Please be seated. Seeing none, respondent.
Thank you.
Mr. Chair, just a point of information real quick.
Member Wolf.
Before the respondent speaks. The complaint seems to be focused specifically on a person to provide the information, not on the organization as a whole. And I'm wondering if that person is here today. Because if the person is not, then I think we should ask if that person is here, Mr. Kanakita.
No, he is not.
Then any other persons that would be presenting any further evidence, it would then move to a person presenting further evidence.
Well, the Bay Area Video Coalition is listed here as a respondent. Mm-hmm. And if, you know, he may have made the request to Mr. Ikeda, but my own reading, and Mr. Threet might can correct me if I'm wrong, or Mr. Snyder can correct me if I'm wrong. My reading is that it's the Bay Area Video Coalition that is the respondent. And even if Mr. Ikeda is not here today, if the BAVC sends a knowledgeable person knowledgeable in this matter, then that, as far as I'm concerned, that satisfies. Is there any further thought on this, Mr. Knebber, Mr. Threet?
In the actual sunshine ordinance, it says they're allowed to send anybody knowledgeable on that. It doesn't have to be the exact person named.
67.21E.
I understand that.
Mr. Threet?
Through the chair, if you review the email complaint, which was made on April 14th, it's listed. The responding department is the Department of Technology, parentheses, Bay Area Video Coalition. So it appears to my reading that there are actually two respondents, both the Department of Technology and the Bay Area Video Coalition.
Mr. Chair,
Member Wolf?
I'm referring to the original immediate disclosure request of March 21st, which specifically is addressed to Mr. Kanakita.
Okay, this is on page 55 of our packet.
And the complainant is specifically asking him by name, Mr. Ikeda, please provide me with this information. Then it doesn't matter. If it doesn't matter, then that means that it doesn't matter who makes a request to any specific employee in the city and county of San Francisco. It means anybody can then respond. And I think we've been through this pretty heavily, that when requests are made to a specific person, that they are the custodian of record under the current law, and that they're the ones that are required to respond. correct me if I'm wrong.
Member Cawthon and Member Johnson.
I had a question for Ms. Hodge. Ms. Hodge, does BAVAC get $250,000 from the city each year?
I am not sure about each year. I believe that the year in question, this last year, that threshold was met, and I don't have information on the ongoing finances.
But you do know that would be dispositive.
I believe that's true of this, that this year that threshold was met. The Department of Technology may know exactly what those numbers
because
are.
my question is
Point of order, Mr. Chair. We were having a discussion on a different thread and not actually moving forward to speak on the merits yet. My concern is whether the appropriate person is at the podium. Can we finish with that item first?
Member Johnson.
That's fine. Through the chair to Member Wolf, is it that it's directed to, it's common practice to direct to a company issue one request for documents or information, and because within the body of it, it's not necessarily related to Mr. Akita, but the actual company, does that make a difference to you in your opinion of whether he has to be here?
Through the chair, yes, it does, because if he is the custodian of records, if Mr. Pescarella knows that that person has custody of those documents, then he's asking that person to produce the documents. And that's why he addressed it to Mr. Kanekada, the executive director. He didn't address it to just Bay Area Video Coalition and request the documents of the organization, which then anybody from the organization could provide it. It's in the same way if somebody were to ask something from the Planning Commission or from the Planning Department. If they asked the specific employee or staffer or department head from the Planning Department to provide a document, and that document wasn't provided by that individual.
Even though these particular documents are related to the company as opposed to the individual grants, and the city of California, the city and county of San Francisco requests for proposals are not specific to an individual, they're specific to a company?
But
Does that?
Through the chair again, what documents in the Planning Department are applied to an individual? We're just talking about people that are responsible, custodians of those records.
Member Chan.
I think the ultimate question is, does Bay Area Video Coalition has to go to the structure of city government, saying that one is there anything in the ordinance that says how a nonprofit had to be structured or run? It shouldn't be, right? So are you a legal counsel for the executive director?
Not for the executive director as an individual, but for the organization.
And do they have legal rights to get a legal counsel to talk on the executive director's behalf?
They are not allowed to have the city attorney represent them here before us for the purpose of denying a public record. As to whether their own they have an outside counsel come before us. Again, my concern is whether the council or any other representative they send here is knowledgeable in the matter itself, in the specific matter itself. A record was requested, a record was not provided. Why? Okay.
Chairman, can I just
Mr. Threet, then Member Cawthon.
I want to distinguish between a couple of different issues that I think are being discussed as if they're the same. Under the Sunshine Ordinance, if a request for documents, public records was made to a department or to a specific employee in a department, that employee under the ordinance would have the responsibility to respond to that request. It's a different question who can represent the department. Here at the task force, the ordinance provides that someone can be here representing the department who is knowledgeable about the matters on which the complaint addresses. So those are two different issues even under the ordinance. becomes even more attenuated, however, when you move to 12L, because there are not similar requirements under 12L. It speaks of the nonprofit responding, not individuals. There's no onus on an individual to respond in any particular way. The limited requirements of 12L apply to the nonprofit organization itself.
Thank you. Member Coughlin?
Yeah, I just wanted to go back to, my question to Ms. Hodge, because there are a couple of issues here that is BAVAC covered by 12L, and that would have something that would have to do with the amount of money they get in the year, I guess, that the document was requested. Then also, DITAS did say that the document's already been provided. So I'm very confused.
Mr. Chair?
Member
I'm
Knebber.
Again, a point of order. I think we have to allow the respondent to make the statement, and then we can get to questioning about the merits. We can't start asking questions before she makes her statement and her response.
Your point of order is correct. Ms. Hodges, apologies for the interruption. Please continue.
By all means. I believe that what I have to say may address some of these concerns, but I want to first situate this because I'm concerned that we're talking about broad issues around public access television that may be of interest to many of the people in this room, but the task force is concerned about the scope of 12L and the Sunshine Ordinance. So I want to focus on what actually is in this complaint. BAVAC didn't quite receive, but that's beside the point. This letter was submitted that asked for all documents related to the city's contracts concerning public access television, and it evoked the authority of the contract that BAVAC has with the city. And that request is a little bit daunting and a little bit broad, and it may be an appropriate request for the Department of Technology. But for BAVAC to be obligated to respond and to be here before you all, we have to go back to its contract with the city. BAVAC's contract with the city brings us here before you in two important ways. And the first one is this provision that's been cited a few times, and the full text of the relevant paragraph is in the letter that I sent to you all. And it starts with the sentence, BAVAC acknowledges and agrees that this agreement and the application documents are subject to Section 67.24E of the San Francisco Administrative Code, which provides. Which provides is talking about what the code stands for. But the first sentence there makes clear the two kinds of documents that fall within this paragraph, the agreement itself and the application documents. None of which is what anybody here has asked for today because they're available online through the Department of Technology. That's why nobody's talking about the agreement itself or the application documents. And that's what that contract provision speaks to. Now, the other way in which BAVAC comes before you all in the task force is with respect to 12L. And 12L calls for open board meetings, and we do have an open board meeting on schedule for later this summer. And there has been no complaint on file before you about the adequacy of BAVAC's response with respect to the board meetings. And I know I've heard some of the concerns from the public, and I don't mean to dismiss those, but they're not before the task force right now. And so they're not really within what we're talking about. The other kinds of documents that 12L provides for are certain enumerated financial documents, sort of minutes, audits, miscellaneous documents, none of which have been requested, none of which have been what's asked for here tonight and what people have talked about. So this request, which cites the authority of a contract, if you actually look at what those contract provisions speak to, all of the complaints, and I mean that term both broadly and specifically, really don't relate to what this task force has oversight over. In addition, we have two other important problems. One of which is that these complaints are not being submitted in a way that is useful for the task force. They're not being submitted to the Department of Technology. We are receiving these letters via an unregistered fax, which causes them to go into my spam filter. And I'm sorry, I don't mean that to cause a to impose an undue burden. But I've attempted several times to email with, to call Mr. Pasquarelli, and I haven't received a response. And I know this task force has heard some comments about the last time we were here, and I attempted to resolve that matter with Mr. Pasquarelli and didn't receive a response. I think that kind of back and forth is probably of little interest to you all. It takes up an awful lot of my time, but probably isn't terribly concerning to you guys. I think that if there is a way in which this process needs to be mediated with the Department of Technology, I am happy to participate in that process. If there is a complaint committee that oversees this in a way that might allow us to better refine what it is that Mr. Pasquarelli wishes from BAVAC, I'm happy to participate in that process. But what we have here is a very, very broad complaint asking for documents that BAVAC doesn't even have. Some very specific complaints brought from the gallery that aren't actually enumerated here in the complaint that was presented, that aren't a part of what Mr. Pasquarelli requested. And then we have this contract that BAVAC has with the city, and they're just not lining up. And if we go back to the contract that BAVAC has with the city, BAVAC has complied with all of those provisions, and the requirements of that contract, those documents that we need to disclose are already online, which is exactly how I expect Mr. Pasquarelli referenced them for purpose of preparing his letter. I'm happy to answer whatever questions you all may have, but I believe that concludes my statement.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Sir, if you have facts and evidence in support of the respondent, then it is appropriate.
Thank you, Chairman Nee, Task Force. I'm Barry Frazier, an analyst with the Department of Technology. Just a couple of points. We received, to my knowledge, one request for documents from Mr. Pasquarelli. On December 16th, I believe, we received a fax request. We complied with that request on the next day, the 17th. We provided, we believe, all of the documents that Mr. Pasquarelli requested, and we didn't receive any kind of follow-up or any communication from Mr. Pasquarelli stating that there were additional documents or that he didn't get what he wanted. We received nothing else from Mr. Pasquarelli since December 16th. We have not received any communication from Mr. Pasquarelli with respect to this particular request for documents, and that's really all I have to say, other than I'm here to try to help the task force resolve this, and I'd certainly be willing to talk to Mr. Pasquarelli to see if there are any documents that are outstanding that he didn't receive or that are not available on our website. There is no 50-page budget. I really have no idea what that document might be. There is no budget that's 50 pages long that we have. It may be that the best resolution for this is for DT and Mr. Pasquarelli to get together and try to resolve what documents he's looking for and whether the department can provide those documents. And if the department can't provide those documents, then perhaps he needs to come back here and complain. But we haven't had any opportunity other than that one letter to provide him with anything. And I believe Mr. Pasquarelli would be willing to chat with me outside and see if we can't come to some resolution. So I offer that to try to move this along.
Thank you.
Chair Nee?
Not yet. Is there anybody else to present facts and evidence in support of the respondent?
Simple case.
Seeing none, the matter is with the task force. Member Cawthon? Excuse me, sir. Please be seated.
I just wanted I like what Mr. Frazier said, and I just wanted Mr. Pasquarello, if he could come up, because there seems to be some confusion as to whether or not the documents have been provided. The department seems to feel they have, and Mr. Pasquarello seems to feel they haven't. And Mr. Frazier is willing to talk to Mr. Mr. Pascarelli, so are you willing to? Well, let me ask you the first question. Have you gotten everything that you've asked for?
No, I haven't. Two corrections to previous statements made. As far as I know, the attorney, Hodges, never phoned me. Okay, that's never phoned me. I have a 24/7 message machine, PAC Bell, on my phone system. I never received any messages from her. I gave her my business card when we were here February 23rd. She's never phoned me. I asked her by way of a fax to send me everything at my post office box. That was months ago. So they had the lines of communication had been open for many months. In fact, prior to this complaint being filed, I believe. I'm sorry. Did you ask me a specific question?
The statement has been made that DEDIS has the information. Let me just finish. The statement has been made that DEDIS has the information you're seeking. Mr. Frazier is willing to work with you to see what it is you haven't gotten that you want. Are you willing to do that?
Well, I appreciate that, but I need to make one more correction. I did make, as I think I stated earlier today, a second request of the Department of Technology by way of a fax. It is based on this document that they sent me. Okay, these pages. This is, and I'd like to enter this into your record. It says at the top, BAVC, Bay Area Video Coalition, top right-hand corner, and the first line reads lowercase II, budget, comma, year 1, comma, budget, and budget projections, comma, years 2 and 3. And then there's a multiple column breakdown of what gives every appearance of being the budget for the Bay Area Video Coalition, the bottom line of which reads, from left to right, Bay Area Video Coalition, Public Access Proposal, page 22 of 55. That is what I requested in my second request to the Department of Technology, which they ignored. They never responded to. I am willing to work with Mr. Frazier, but the caveat still is, of course, I always have the right to return to this body if I don't receive the public documents that I believe I'm entitled to.
So what you're looking for is that 55-page document. Is that correct?
As well as the matters quoted verbatim from the Bay Area contract of August 20th. Those two sets of documents. I
just wanted Mr. Frazier to come up again if he would. So, and you stay there too. Mr. Frazier, so do you have the documents he's looking for? Are you willing to talk to him to see if you can give him the doc? Are you willing to give him what he wants?
I believe so. We did provide these documents. The document that he's referencing is the proposal that BayVac submitted as part of the RFP. That is available on our website. I can download it for Mr. Pascarelli, or I can provide him the link, or however he'd like to get it. I will make sure he gets a copy of it.
Okay.
With respect, well.
And then is there anything? There's another document that you want besides that one, right?
Well, it's the basis of today's complaint, which is I don't have it in front of me, but I read from the contract the specific sunshine section of the contract, which apparently is something that the Department of Technology can provide, and I would like to receive that.
I'd like to know, Mr. Frazier, can you provide that? Do you know what he's talking about? Can you provide?
I'm not very clear what he's talking about at this point.
What are you talking about?
Get the contract again and read.
Please approach the microphone, Mr. Pascarello.
Should I get the contract and read it again? I did before. I'd be glad to read it again to you.
Well, just give us a thumbnail statement of what it is that you want that you haven't gotten.
Well, with all due respect, I'm not interested. I don't want to be imprecise in my response. So I'm asking for what's verbatim in the contract. That's what I'm asking for. So I cannot cite it verbatim from the contract. I don't have it memorized. I can read it to you from the contract spec in the back of the room.
Mr. Frazier, are you willing to give him what it is that he wants when you find out what it is?
I believe that what Mr. Pascarelli is asking for are all documents that would be responsive that the department has with respect to the section on contracting. I don't have the number in front of me. I think we have most all of those documents available on our website. There may be. Well, I know that these two documents aren't there, the budget, but he has them. So, again, I think I will provide Mr. Pasquarelli with everything that he's requesting, even though we don't have a records request for this. I wanted to make that very clear. We never received a follow-up from you. Maybe it got lost somehow, but we haven't received any request for documents other than the one that we complied with on December 16th. But with that being said, I will take this as an oral request, and I will provide the documents that we have that we believe are responsive to that we're required to provide under the contracting section of the Sunshine Ordinance. And all of those documents, as I said, are available on our website. And I don't know any other way to comply other than to provide everything we believe we have. The language in Section 12.2 of the contract is really verbatim taken out of the Sunshine Ordinance. So it is extremely broad, and it's I don't know that it's very helpful in clarifying or narrowing the types of records that Mr. Pasquarelli is really looking for. But I will we'll chat, and we'll try to work it out.
Yeah, I mean, Mr. Pasquarelli, are you willing to work with him and attempt to get what you're looking for, with the knowledge that you are perfectly free to come back here if you don't get everything you want and you think it exists?
Yes, yes, I think Mr. Fraser misstated. I don't have this document. I only have 2 pages from the budget proposal. So it's unclear to me where that is, whether you suggested it's on your website.
Well, he
sir?
says he's going to work with you.
Okay,
and
the
give
two
it
of
to
you can the
Are
two of you can work
Are
together
you
on
willing
this.
to do that?
Appreciate
Okay.
your help. Sure.
That's what I'm trying to just establish.
Thank you.
So good. Thank you.
Mr. Threet, Member Wolf, Member Knebber.
Jerry Threet with the City Attorney's Office, through the chair. Just to clarify, the complaint that's before the Committee for Adjudication involves a request for a copy of all contracts, grantee bids, responses to requests for proposals, and all of the records of communications between the city and persons of entities seeking contracts. This is about the contract documents between the city and the nonprofit. The complainant has, and those offering testimony in support have also mentioned a separate issue, which is not before the task force for adjudication tonight, and that is the budget documents, which the complainant says he has twice requested from the Department of Technology. That issue is not before this task force for adjudication. It's perfectly fine for the task force to mediate both issues in the hopes that they won't come before you for further adjudication, but I just want to clarify that that second issue is not before the task force.
Thank you, Member Wolf, and then Member Knebber.
On the point of the our focus is on this complaint, in the in our agenda we have those documents, those requests from to and from the Department of Technology. So while the focus isn't on the actual complaint that's before us, I believe this is what led up to Mr. Pasquarelli going directly to BAVAC and asking for the information directly there. I have tried to find these documents on the Department of Technology's website at home, and I'm actually on it right now, and there is no place anywhere that has a repository of any documents that I can find. I'm looking at it right now. If you want to show me, I'd be happy to. I just been through every single link on your website, and you can come forward. That's Public Access TV. That's not Department of Technology.
Yes, it is. That's our.
This is not your website?
Yes.
And so where on this website?
Future of Public Access
Okay.
TV.
And that's where documents are?
That's the same. That will take you to this link. We created this link for the public to make it easier to get there.
Future of Public Access. Okay. All right. Okay, thank you. I'll peruse that as we continue. The next question I have is regarding 12L, and I don't know if we the question is we took jurisdiction on this. The question is we took jurisdiction on this based upon the complaint with regards to 12L, and I'm concerned that the decisions that members might take on 12L, specifically 12L.5, will come into play because we don't know for sure what the accumulative funds that BAVAC has received thus far. It's not just on one contract, it's everything. So, and that's the way I read 12L, and I've been reading it, that particular section. So I'm a little concerned, and I would like to ask BAVAC if you can provide us with information on, to date, what your...
Through the chair, I think she's already admitted herself that they've had more than that this year.
Okay.
During the year of this, when this contract comes into date.
Okay, I may have missed that. Thank you, Mr. Knebber. So if that's the case, then we are within jurisdiction 12. Okay, then that's it. That's all I have. Thank you.
Member Knebber.
I would like to get back to the case, and we've gone all the way around in circles, and for the same reason why I oppose jurisdiction on this case, I'm going to say that I would move when the appropriate time comes to find I'd move for no violation because I don't think that it has been through the proper channels. I don't think that it has that it actually meets what we need. If this case was brought before for the Department of Technology, don't get that information, okay. But from what I've seen, what's going on, I just think that we need to speed this up and move on.
Okay. At this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. Ms. Hodges.
Thank you. I'll try to just make this brief because I believe I was clear in my opening statements. The requests that are before us simply don't speak to many of the comments and the conversations that we've been having off record. And with respect to the complaint itself, it asks for contracting documents and requests for proposals which are available online and readily accessible through the Department of Technology. And to the extent there even is a 12L issue here, there hasn't been any alleged violation. No one has accused BAVAC of not opening up its board meetings. Nobody has suggested that BAVAC has not provided the enumerated documents under 12L. So we're really just looking at the accessibility of these contracting documents and requests for proposals, which are available online. And to the extent that BAVAC needs to download them and mail them, I'm not sure that the task force wants to impose that obligation on a nonprofit. But if the issue here is one of responsiveness, and I think that may be part of what's going on, I want to be clear that these requests for specific documents, a budget, those haven't come before us. I don't have that. I don't know what that's about. The letters that I do have were sent by an illegal unregistered fax. That doesn't mean a fax that you just chose not to register. It means you have to actually disable the registration functions, and that triggers my spam filter. And I realize that I don't know, that may seem lame. That may seem a little bit of the back and forth here. But what's happening is that we're being asked for documents, and we're not really given an easy vehicle with which to respond. And the documents we're being asked for are not really within the purview of what we're obligated to provide. And finally, the documents that we're being asked for are already made available online. So to the extent that the task force sees this as its own issue, I think it's an issue that is well resolved by what the city has already done. But if anybody has other concerns and would like to talk to me about them after the meeting, I'm available to those people who have voiced them in the audience.
Thank you. Ms. Hodges, quick question.
Yes.
You say the requested documents are available online, correct?
The contracting documents and the RFPs.
Did you inform the requester of that fact and direct them to where they can be found online?
Once I became aware of the complaint and the request itself, which was not something that I received.
Okay, but
until
either
it came to
either you or BAVC has let the requester know that the documents are available online and where he can find them?
Yes, he's received that via letter from me, and that information is also available to the public as a whole on the BAVAC website.
Thank you. Mr. Pasquarello? You have 3 minutes to make any concluding or rebutting remarks.
It's quite possible that this hearing might have been avoided if the attorney had communicated with me prior to even filing the complaint, when I requested that BAVAC send me the documents that are mentioned in their contract. I received a letter yesterday, which I believe is in your record, dated May 20th, from Chrisana Hodges. This is so late in the process of what we've been going through that I think it begs the question of how sincere or forthright BAVAC has been. Also, in the context of my prior complaint here, BAVAC just does not respond. I am also a public access producer, and the Board of Supervisors, a committee of the board, as you may or may not know, a committee of the Board of Supervisors has suspended the payments of the city and county funds to BAVAC because there are so many questions about the operation of BAVAC. So there are broader issues that this relates to. It just begs the question of how forthright they want to be with the taxpayers and the government officials of the city and county of San Francisco, of which you are part. I hope, frankly, I don't have to come back to this body to request any other public documents. And I have some concerns that anyone should say they're online and therefore we've met public records standards, because not everybody has access to online or in the high-speed manner that allows ready access to documents online. So I have my own doubts that constitutes a proper enforcement of public records law. I do appreciate your help, and I look forward to getting all these documents. Thank you.
Thank you. The matter is back with the task force. Member Kneber.
On this matter, while I don't agree with the details of the respondent's argument, I do think that based on a lot of the stuff I've said earlier, I don't mean to go into it again, I do think that this matter, we need to find it's difficult because I don't agree completely with the detail. I do think that there are things that nonprofits, especially under 12L, are required to do, and I think that our respondent is a little bit misinformed about what she needs to do. But in the end result, I agree that that we don't have something to go on here.
Member Coughlin.
I just wanted to say that I do think there was a lag in between the request and what we're now hearing today. And I did see a long letter from Ms. Hodge, but it basically said, you don't really have jurisdiction and we're not the right place, and on and on. However, we learned from Mr. Barry Frazier from DEDAS that indeed the documents do exist, that he will get them to him, that BAVAC also has them. I just think there was a lag in response. I don't think that the withholding of documents was sufficiently justified. So I would find a violation. I would commend them now for being willing to work with Mr. Pasquarello, but I think there was definitely a violation. It was an untimely response.
Is that a motion?
So I would move violation of 61.21 for an untimely response to a records request. I don't know the section.
Is there a second?
I second it.
Moved and seconded. Discussion. Member Knebber?
Again, I just don't think that I could support that. I would have to vote against it because, again, I don't think it was gone through. It didn't go back through the Department of Technology properly. So again, that's why I voted that we didn't have jurisdiction in the first place. And for the same reason, I don't think that we can find a violation in this matter.
Member Wolf?
Yeah, I want to be clear on this because I'm going to be very exact with regards to what the immediate disclosure request by Mr. Pasquarello to Mr. Kenakeda of BAVAC. Specifically in here, he cites Article 12, and specifically his request is for contracts, grantee bids, responses to requests for proposals, and all the records of communications between the city and persons or entities seeking contracts. Okay? If we specifically look, and you're probably not going to like my answer on this. Some folks in the gallery. If we look at 12L with regards to the information that a nonprofit is supposed to provide, it's listed under 12L.5.A. I'm not going to read the whole thing, but I'll read just the listing of what those items are. Each nonprofit organization, under this section, each nonprofit organization shall maintain and make available for public inspection and copying a packet of financial information concerning the nonprofit organization. The packet shall include at minimum 1, the nonprofit organization's most recent budget as already provided to the city in connection with the nonprofit organization's application for in connection with review and or renewal of nonprofit organization's contract. 2, its most recent filed state and federal tax returns except to the extent those returns are privileged. And 3, any financial audits of such organization performed by or for the city and any performance evaluations of such organization performed by or for the city pursuant to a contract between the city and nonprofit organization to the extent that such financial audits and performance evaluations small letter I, are in the nonprofit organization's possession. 2 I's may be publicly disclosed under the terms of the contract between the city and the organization. 3, related to the nonprofit organization's performance under which the contract with the city lasts 2 years. I'm not seeing a one-to-one correlation between what the request is, the specific documents, and what 12L5A is describing. Okay, so for me, it's like I said, I'm going to be very exact, and we all have to. It's what we're here for, is to make sure that the documents that we're asking for is the documents that the law provides for us to be accessed. Okay, I'm going to say that. That's all I'm going to say for now.
Member Williams, could you please speak into a microphone?
Please give me.
So it's 12L.5.A, disclosure of financial information. Thank you, Mr. Chair.
Okay. Further discussion? Is there public comment on the motion to find violation of 67.21? And I believe the actual subsection to which Member Cawthon refers would be 6721B for beta.
Hi, members. Kimo Crossman. I'm in favor of that motion. I think the nonprofit has acted in bad faith. You heard that they were sending letters the day before the hearing. They spend half of their defense complaining about a fax machine that doesn't have a phone number on it, as if it's a federal violation. And I want to just throw something out here that hasn't been discussed. There's an assumption that nonprofit actions only apply under 12L, but actually, and I don't know if this has been thought about, but I'll just throw it out for consideration. After Prop G was passed, the city attorney did an analysis of what the new provisions in Sunshine meant, and part of their analysis had to do with how it affected nonprofits. And let me just read you 3 points that the city attorney made at the time. Basically, if a nonprofit is acting in a governmental fashion, then 67.4B requires disclosure of records by city contractors and grantees, including nonprofits and religious organizations that perform a governmental function related to health, safety, and welfare. 67.296 requires disclosure of records of any entity that provides more than $100 to the city to carry out civic functions, activities, and public events. And 6729C requires disclosure of records of vendors who collect fees or funds on behalf of the city. The city is also required to retain accurate records. So I want to point out that those 3 provisions that were analyzed by the city attorney can potentially apply to a nonprofit if they're working in a governmental fashion, or again, there's 67.4B, 67.29-6, and 6729-7C. Those are on top of the provisions under 12L that don't, if any of these apply, then this whole prior consultation that's required under 12L does not apply. So again, I am in favor of finding the nonprofit in violation.
Thank you. Is there further public comment?
Members of the task force, for those of you who are new, my name is Ray Hartz, and if you haven't been warned about me already, you will be. I rise in support of Mr. Pasquarello's statements. I really do understand why he would be leery of offers being made at this last minute to cooperate with him. Give you an example out of the testimony. The representative from DTIS came up and said, well, we got the request in December. We never heard anything back, and so we assumed everything was fine. Well, bottom line is, if I'm a city agency and I get a complaint against me, I think that's pretty clear notification that someone thinks there's something wrong. And if you honestly want to give the documents or work with the person to give them the documents, you can pick up the phone, write them a letter. If you can't communicate with them, there are multiple ways to arrange that, and they did none of that. They waited till they got here at the very last minute when it looked like they might be found in violation, and then said, oh, yeah, we'll work with him now. And again, I agree with him wholeheartedly. I think they've shown a systematic show of bad faith. And as a result, I think it's very, very unlikely that there won't be further problems if he simply says, yeah, I'll work with them, and then we'll be back here in another month or a month after that.
Thank you. Is there further public comment? Excuse me, Ms. Rosenberg, you have already spoken, presenting facts and evidence in support of the complainant. Therefore, you are not considered a member of the general public. Please be seated. Please be seated. Please be seated. Please be seated. Further public comment on this item, on the motion.
In fact, I think we're talking about public records, not documents, which are a lot of pieces of paper or electronic formatted records, but these are public records. And I think there's a core issue here. If a not-for-profit is formed for the purpose of performing a function that had been previously performed by a city agency or city body, and then they offload it to the not-for-profit, does the character of the records they maintained before, which were public and accessible under the ordinance, suddenly become subject to a different set of rules? And frankly, I think this is a problem because we know about the Friends of the Library and the inability to get records out of the Friends. And I'm concerned that if this gets, if there's some momentum on this, there'll be other cases where agencies or public bodies decide they want to offload into a not-for-profit and therefore limit accessibility to public records. Thank you.
Thank you. Is there further public comment on the motion? Seeing none, public comment is closed. The matter is back with the task force.
Call the question.
Question has been called.
Point of information, what sections are we citing a violation?
Okay, the motion is to find violation of 67.21B dealing with timeliness of response. Is there further discussion by the task force? What is your point of order, sir?
Is this violation against DT?
The violation is the violation is against BAVC.
Thank you.
All right, Member Washburn.
I've been listening to what Mr. Crossman and Mr. Grossman had to say, and citing what our city attorney said way back when. And I think they make a good argument for before this BAVC is acting, is performing a governmental function. And if that's the case, then not only were they late in responding, they were improperly withholding information. So I'd like to amend the motion.
You're offering an amendment to the motion?
Yes.
Okay, and that amendment is?
67.26.
Okay, now would that substitute for 6721B or would that be in addition to?
In addition to.
Okay.
What is that? Failure to justify withholding? Is that what's 67.26?
Yes, withholding kept to a minimum.
Okay, that's fine.
Okay, there has been a friendly amendment offered to that motion. Does the second accept?
Yes.
Does the maker accept?
Yes.
Yes.
Okay. Question has been called. Before we have the roll call, Mr. Threet.
Through the chair, Jerry Threet with the City Attorney's Office. I think it's important to look at the specific sections that were cited by the public commenters to see whether they actually apply in this situation. 67.4 is a very limited provision that says when as it's been described by the members of the public, city functions are offloaded to a nonprofit. There are certain requirements that will be applied, but those requirements are specified in 67.4, and they're very limited. They do not mean that the entire ordinance and all of its provisions suddenly apply to that nonprofit.
Thank you. On the motion, roll call, please.
On the motion, Member Snyder? No. Snyder, no. Member Cawthon?
Aye.
Cawthon, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? No. Knebber, no. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Williams? Aye. Williams, aye. Member Nee?
No.
Nee, no. Mr. Chair, we have 6 ayes and 3 noes.
The motion carries. Okay. This matter will now be referred to the Compliance and Amendments Committee for follow-up. At this time,
We'll never get out.
at this time, we will take public comment on items not on tonight's agenda. This is general public comment.
Chairman Nee, members of the task force, again, my name is Ray Hartz. And if any of you have never been to Spain, I would say if you get a chance to go to Spain, go to the city of Granada and visit the Alhambra. And there are some rooms and buildings in there grouped together known as the Nasrid Palaces. And one of those rooms is the Golden Room, where the Sultan would hold all of his important meetings and make all of his important decisions as commander-in-chief of that area. And over the door of that, they had a phrase. And it said, "Enter and ask. Do not be afraid to seek justice, for here you will find it." Very noble. In December of 2008, I filed complaints against the San Francisco Police Department and the San Francisco Police Commission for violation of Section 6729 for failure to maintain the index of records. Determinations were issued in both of those cases, finding them in violation, and contrary to your own rules, which I have raised this question before, it was sent, instead of being sent to compliance and amendments, it was sent to the EOT, where it was radically mishandled. Hearings were held to which I was not notified. Hearings were held where there was no quorum and yet testimony was still taken. And constantly, in addition to that, the chair of the committee kept giving laudatory comments to the police commission representative and to the police department representative for the efforts they had made. The last I heard of this, they were to have updated the index of records as of May of 2009. And as of this morning, there is still not any entry on the index of records for either the police department or the police commission. So they have just completely disregarded you entirely. And they did so with the aid of the former chair of the EOT. So as of today, I am resubmitting new complaints against the San Francisco Police Department, the Police Commission, and the City Attorney's Office for violation of 6729 index of records. And in the cases of the Police Commission and the Police Department, when I come before you, I will be asking you to find them in willful and knowing violation, because they have had now an additional year to take the necessary steps. They promised repeatedly that they would do them, and they carried out none of them. Mr. Rustin?
Excuse me. Thank you. Is there further general public comment?
First, I'm glad to see Mr. Threed here, as his many comments demonstrate you really need a deputy city attorney here at these meetings. It's unfortunate for reasons that when I have an opportunity to comment again, maybe at the next meeting, we can talk about the role of the city attorney and the way in which their time is allocated among the various departments and agencies they serve. Actually, I'm going to whine again about the lack of minutes. And I think it's really important to understand what the law is. The law requires that the draft minutes of each meeting be available for inspection and copying upon request no later than 10 working days after the meeting. Now, we've had at least 4 and maybe 5 meetings where there are no minutes. There are no minutes, draft minutes, there's no minutes posted, there's not even an attempt to deal with it. And it's really serious because every meeting, in a way, is built on what happened before. If you had heard a matter very similar to the one that you just heard 3 meetings ago, you might have a record of how it was handled, what the decisions were, and it wouldn't be handled on an anecdotal basis. But it's more important because on your agenda is the draft amendment of the ordinance. And at many of these meetings, there were word changes made, submitted to the task force for a vote and a vote taken. And nobody knows what those changes are or whether the vote was A or nay. So you're in a situation where you're dealing in the dark about what happened over the last couple of months on that. The other point, which I've also made before, is the description on the agenda for the taking up of the draft amendment is totally inadequate. The rule in the ordinance is it has to be a description with certain specificity so that the public would know actually what's going to happen and what's going to be taken up. So if you look at the one-liner that's on this agenda and compare it to what the Ethics Commission agenda item was when they took up some proposed rules dealing with sunshine complaints, It's 7 lines. Wait, 2, 4, 6, 8, 10, 12, 13 lines. And it describes the content in a summary way of those rules. And it describes what the action anticipated or contemplated might be. Now, you look at that one-liner, and I've been to all these meetings, and it's always the same one-liner, but it isn't an accurate description because Articles 1 and 2, they're history. Article 3 is history. And yet, this agenda says Articles 1 to 4 will be taken up. And we know that's not going to happen. So the whole process, from an administrative point of view, not identifying the changes, not having the minutes that identify the changes, not having an adequate
description. Could you please wrap your
description.
remarks up, please?
End of story. Thank you.
Thank you. Further public comment?
Hi, Kimo Crossman. First, let me say I concur with Mr. Grossman's concerns about the draft ordinance issues, and let me also pile on with that it's been at times impossible to get a clean draft of the working draft ordinance, as well. A red line version in Word usually was out of date, sometimes by weeks or months. And when we requested numerous times to have a monitor available, oftentimes the monitor was actually sitting in the room. Yet when we asked to have the monitor hooked up to a laptop so we could see the changes as they were made in the meeting, that was never done, that's the standard way of doing group editing of documents these days, is to see the changes in real time as people make changes to them. So it's been quite a mess, and I won't even get into the substance of the current draft. Also, let me say I concur with Mr. Hartz. I applaud his persistence on the index of records. It's an important area that hasn't been given a lot of attention, and it deserves that. And the police department is particularly bad about that. I do want to talk to you about two other issues. One is the role of the city attorney advising you. I do encourage that you get opinions from the city attorney in a written format. There has been problems in the past. The city attorneys have given oral interpretations on the fly in meetings, and they haven't really stood up to research. So I would encourage getting written opinions from the city attorney. But I am concerned about the city attorney interjecting in the middle of a discussion. If you request his advice, that's one thing. But for a city attorney to impose their views when it hasn't been requested, I do have a problem with that. And I actually do disagree with the points he made in the last matter. So with those things, I applaud your efforts. Thank you.
Thank you. Further public comment? Seeing none, public comment is closed. Before we move on to the next item, the chair will declare a 5-minute recess.
Oh, that must be so hard. I didn't know what it was about, but I thought.
So just ask Chris, could you be put back on? But you have to call him and let him know.
Free stuff. It's really interesting, you know, the way these departments work. There's some, for example, DBI. They make you fill out a form.
Jerry.
And to
was
just look at something on a screen
and she didn't show up.
and give them your driver's license. Just to look at it. I know. And at planning, they do the same. They want a form and they want something to keep your.
I think it's a better option. I mean, I don't think they should ask for anything, but if they're going to have to do it, then it's better. Then you're not having to identify yourself.
And if you give them
How are you? No, I don't think he's ever been. He's been active on the FPGA list, but I don't think he's ever been to our meetings. Has Mooker's offices because you? They don't want it. They'd rather see it go away.
Before you came, he had they asked him some questions.
Yeah, but you see how he jumped in at the very end of that? The very end of that last one?
Yeah.
With no one asked him. Yeah, I know.
Comes to the meeting.
You know, I was thinking
wanna-
about some later. Right, yeah.
It will be in the ECC report.
Right,
Because we can,
yeah.
And to my son, I said, your people. Oh, that is so
girls are wonderful. Yeah. Well, I had one of each, and my son pretty much tormented my daughter for a good part of her life. Yes, 2 years older. They're very close now, but oh my. Was he older than you? Same with mine.
Back to you guys.
Yeah, I mean, once in a while, I have to consult.
Mine does.
We are back in session. Mr. Clerk, could you read the next item, please?
Yes, Mr. Chair. Item number 8 is determination of jurisdiction on complaint filed by Alan Sang against the Planning Department for violating sections 6721A, B, C, D, and I, 6721-1, A, B, and 67.34.
Okay. Is there a motion to accept jurisdiction?
I move we find jurisdiction on the matter.
Moved and seconded. Discussion. Is there any public comment on the jurisdiction question? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder? Aye. Snyder, aye. Member Cawthon? Aye. Cawthon, aye. Member Washburn?
Aye.
Washburn, aye. Member Caneba?
Aye.
Caneba, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Williams? Williams, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 9 ayes.
Okay, that takes us to the merits of the matter. Is Ms. Chang present? Thank you for coming. You have 5 minutes.
Thank you. Good afternoon, President Lee and Commissioner. My name is Ellen Sang. On March 11, 2010, I requested 5 specific documents, records from planner Jonas Ioni and staff of Planning Department. The Planning Department refused to provide those documents to me. And on April 14, I filed the Sunshine complaint. And on the April 21st, Mr. Rostam of the Sunshine Commission emailed my complaint and my attached document to 5 planning officials, including the director. He notified each of them that I quote, the department is required to submit a response to the charge of the task force within 5 business days of the receipt of this notice. Planning Department ignored the requirement and failed to submit a response to the charge. In the same email, Mr. Rostam informed them that any support document to be considered by committee members prior to the meeting must be submitted by 4 p.m. Tuesday, May 18, 2010. And planning submit nothing. And as of today, before you, I received no document or none of these 5 documents from the Planning Department. Evidence of this document existed is the emails between the planner Jonas and the architect of the project at 2642-44 High Street. And planner Jonas and Planning Department possess those public records because of the specific documents that are required by the Planning Department. and in order for the planning department to approve the project. Planning department approved the project, and the permit is currently being appealed before the Board of Appeals. I need the specific documents to prepare for my briefing to the Board of Appeal, which is due on or before June 3rd, 2010. Please order the planning department to comply with the law and produce this public records immediately. Thank you very much.
Thank you. Is there anybody here to present facts and evidence in support of the complainant?
Oh, I have one more thing.
Continue,
My time's
please.
up.
Go ahead.
Okay. I just want the record, so public record. So yesterday, I even emailed to the planner and the planning department. I said, list again those 5 specific documents. Ask them, if you do not intend to waste more staff's time, please identify those specific documents and email them to me. I heard nothing from them. They have not produced anything to me.
Okay.
Thank you.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? You have 3 minutes, sir.
Good afternoon, President Nee and Commissioners, anonymous tenants here. This is a simple case where planning does not want the public to have access to public records, especially if it involves another hearing. We had a case against planning for the exact same violation. It took over 9 months to obtain the records, and thanks to you and Sunshine Posse, they released documents, but many months after the hearing was over. We found that the planners have their own separate files, which are different than the files that they let the public review. It seems that planning staff, they have a secret code to prevent the public from obtaining public records. We've heard many people complain about this. If planning cannot obtain, if the public cannot obtain the records in time for the case against illegal construction, then the public cannot present an adequate presentation at a hearing, therefore loses their case. This seems to be the end result of planning's behavior. Excuse me. It amazes me how the public employees refuse to work for the public. This behavior is not for the best interest of the public. Ms. Sang requested these documents and requested that planning identify these documents. Planning did not respond. Planning should have these records because this is an ongoing hearing. If they don't have these records, then they are in violation of not keeping proper and adequate records, etc. We respectfully ask you to demand that these records be provided in time for the hearing. Thank you very much.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you for coming, sir. You have 5 minutes.
Good evening, Commissioners. Jonas Ionin for the Planning Department. I've come here to argue to you that we have actually responded to Ms. Tseng's request repeatedly over the course of many years over which this particular project has taken its course. I'd like to provide you some context in getting to the March 11th email for you. The email, the public record request is specific to a project at 2642 and 2644 Hyde Street. On November 2nd, 2004, a building permit application was filed. On December 21st of 2004, a variance application was filed and a case was created because the planning department determined in its review of the building permit application that in order to legalize the proposal, a variance had to be considered and granted. On May 25th of 2005, a variance hearing was held and the variance was granted. On July 13th, 2005, a variance decision letter was issued. On July 25th of 2005, a variance decision letter was that variance decision letter was appealed to the Board of Appeals by this same party requesting this public record. On February 20th of 2008, the appeal was heard and the variance was upheld by the Board of Appeals. On March 13th, 2008, a request for rehearing was denied by the Board of Appeals. On March 27th, 2008, the Board of Appeals closed that case. Sometime in June of 2008, the original planner who was involved with processing the application and the variance put up her hands and had had enough, and the case was actually transferred to me. And so I was reassigned to work on this specific case. The building permit application was processed. I had requested revisions from the application to adhere to the variance. And on July 2009, the 311 notification or neighborhood notification was sent out. On July 10th of 2009, a DR was filed, case number 2009.0642D, by the same party requesting the public records. On September 17th of 2009, a DR hearing was held before the Planning Commission. And the Planning Commission unanimously decided not to take DR and approve the permit as it was proposed. And I should note that the extent of the permit under question is to legalize a balcony approximately 12 feet wide by, and to reduce the depth of the balcony. The illegal balcony built without benefit of permit many years ago is about 4 feet deep and 12 feet wide off the second story. The permit, the extent of the permit was to reduce the depth of the balcony to 3 feet or thereabout, 3 feet and about 12 feet wide, about 5 foot setbacks on either side from each side property line. On April 9th, 2010, the building permit application was issued. This is a 2004 permit, was finally issued. And on April 23rd of 2010, the building permit application was appealed to the Board of Appeals by the same party that is seeking this public record request. On April 27th, 2010, the building permit application was suspended by the Department of Building Inspection, pending the Board of Appeals action. There's a tentative date of June 30th, 2010 for that appeal hearing. March 11th, I did receive an email request for public records. And I should reiterate that over the course of the past close to 6 years, we have repeatedly provided the public requester with the dockets of the cases, the building permit application revisions as they came in, copies of the emails that were submitted, the Board of Appeals files, the 311 notification files, PDFs that were submitted to the planning department were emailed to them. We made a disc of all the emails that were submitted to us. We made tape recordings of hearings that were held as a result of this balcony reduction. The email at hand and the public record request at hand on March 11th. I'd like to go back to the original email that was generated as a result of this March 11th request. On March 1st of 2010, I received an email requesting an appointment to speak with me. On March 3rd, I responded asking what information specifically they are looking to ascertain. On March 5th, I received a list of information to which I replied to on the same day, that afternoon. On March 8th, I received another request of additional information, which I replied to the following day on March 9th. On March 10th, I received another request for yet additional information, to which I replied to, that same morning, a couple hours later. And this is my response.
Okay, sir, you're for two things. You're well over your 5 minutes.
I'm sorry.
Second, what we're really interested in is specifically the request that was received March 11th. All that other stuff that's gone before it, or that's not part of what we're talking about here. Please be seated. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matters with the task force. Member Cawthon?
I have a question, Mr. Eonin. Ms. Sang is asking you for Bob some records that Bob Middlestat created, the architect created, right? That's what she's asking for. She's
That's
asking you
correct.
for 4 documents that Bob Middlestat created. So did you give her the assessor's map? That's what she wants, the assessor's map.
Well, what I was going to get to as far as my last response to her original request for those that came prior to March 11th was that we had provided her with this box of documentation of everything that we have on record with that particular case on numerous occasions in the past.
I know you've been doing it for 6 years. I know there's been DR. I know I know planning a bit, so I know that this is a long haul. What I want to know is what she wants. She is contending there are 4 documents that she wants: the assessor's map, the legal description, the plot plan, and the second floor plan. So what I want to know is, did you give them to her? Do they exist? And if they do exist, did you give them to her?
They do exist, but the specific items, the plans especially that she is requesting, I am not at liberty to provide to her.
But can't she look at them?
She can look at them, but she needs to request them from the Department of Building Inspection, which I directed her to do on March 10th.
So you're saying, but you can give her the assessor's map.
The assessor's parcel map I can, but I don't believe that's what she's requesting.
Well, that's what it says.
She's requesting the legal description of Lot 17 that was provided to me on June 20th of 2008.
Can't you give her the legal description? You can just get that from the assessor. Can't you just give her the legal description?
I can't get it without actually physically going down to the assessor's office and requesting it the same way she can.
Well, can't you did you direct her as to how to get this information? See, one of the things Sunshine requires is that if you don't have it yourself, tell the person how to get it. And so if you don't have access to these documents, what you need to do is tell her how to get them. So if you could just go down and check down those 4 items she wants and tell me what your response was and how she can get them. That's the assessor's map, the legal description, and then Bob Middlestat's plot plan and second floor plan.
Okay. The first item, Architect Middleset stamped and signed set of revised drawings provided to me on February 13, 2009, was a revision to the building permit application. That building permit application was signed off and forwarded to the Department of Building Inspection, and it then goes through their process. And once that building permit application is issued, in order to gain a copy of that plot plan and those stamped, signed drawings, you actually have to get the owner's authorization as well as the architects who stamped it. We have, and I have provided to her repeatedly, PDF versions that actually don't have the stamp on them. I've emailed them to her in PDF form. They are identical to the plans that were forwarded to the building department with the license stamped. And they are the same plans that were sent to the neighbors through the Section 311 notification process, which is why I had them in PDF version.
So if they were sent out through 311, they're available to everybody.
The unstamped version is available to them.
So what's the difference between the unstamped and the stamped
It's a
version?
state law. It's a copyright issue.
It's a stamp. So is Ms. Sang willing to accept the documents that don't have a stamp on them?
I've sent them to her. Apparently not.
You sent them to her?
I sent them via email to her.
Oh, Ms. Sang, could you just let me know what you say? What do you have to say about whether you got those 4 documents?
This project has been delayed because they have been handled by permit expediter Jamie Paul, and then with the connections that just fly, and then when you find out what is wrong, and then you're asking for record, and then they won't give to you. This plan has been have 13 revisions. I don't know what the final one look like. During the time when when we request for hearing, the hearing is heard, then you get some documents, and then there's a revision. So what is the final? Do I have the right to know when people build something illegally about a few feet from your bedroom and overlook your bedroom and throw a cigarette?
Ms. Sang, you're asking for 4
documents. This 5
right?
documents I asking is in the email between. I already expect I emailed to you. It's in the email between the planner Jonas and the architect themselves. This is not I created. The permit is not issued until April this year. So this one.
I'm sorry, I'm not finished. You want 4 documents.
Yes, I list the 5. Mm-hmm.
Mr. Ionen says some of them he doesn't have, and he told you where to go to get them.
No, he never did.
He didn't.
You know, this is something I really puzzle. Your task force allowed this kind of so-called production document. I filed the complaints, have so many days they can produce and they can talk to me. None. Before you bring a box and say, hey, that's what hey, this might be a pornographic movie between the zoning administrator, Larry Bettner, and the high official, like the senior planner, in the newspaper. I don't know what is inside. And then why don't they give to you when you ask them? Why don't they give to me yesterday? There's no correspondence. And bring the box and tell you, hey, we have this much. And so that they won't have to give you public record until it's done.
So Ms. Sang,
yeah,
what you're saying is he's saying that he would give them to you, but he can't give you the stamped ones. Are you comfortable with the ones that don't have the stamp on them?
No, after 13 revision, I wanted to know what's the final plan they are submitting. Why the public cannot have a right to know what is the architect willing to sign under oath? This is it, you know. I can draw something and then give to you and say, hey, this. If they don't have the record, they are honest. That's different. The original plan is 163% larger than they.
Well, let me ask you one more time. I've gone down to the planning department, and I've asked to see plans, and they've let me look at them. They won't let me copy them, and they won't let me take them home, but they've let me look at them. Have you been able to look at the plot plan, or the second floor plan?
They don't have in the box they give to me. Before I filed this complaint, I really looked through one by one and see what is there. How come I find out this? Is it because inside they have an email? That's why I find out this record exists, okay? So I asked them. I can tell you, they don't have problem to produce after the hearing is over, okay? I stand before you. It's for my right, constitution right. I hope that everybody respect that. And also, I follow the processing no matter how long it takes. For somebody have used the connection to grant the things illegally, like fly, somehow we have the right to tell them. We have the right to sit.
I'm just, you know, I don't want to take up too much time with this, so I'm very confused because I just wanted to ask Mr. Ionen, the 4 documents, did you give her the ones you have? Did you direct her to where she could get the ones you don't have?
Jonas Ionen from the Planning Department, yes. In fact, on the March 10th email responding to her original request, prior to the March 11th email requesting the same, I'll read to you verbatim. This is my response to her. The stamped and signed drawings you are referring to were submitted to the Department of Building Inspection as revisions to the building permit application, which have since been forwarded back to them. You may request to view the stamped plans from them. However, they should be essentially the same as the PDF plans already forwarded to you. If they have been issued, they would be located in DBI's Records Division. All of the other information still in possession of the Planning Department have been made available to you, period.
So the assessor's map has been made available to her?
Well, again, it's the description. She's very specific in her request. It's not just the assessor's parcel map, but that I can provide to her. It's the emailed the fax copy of the assessor's description sent to me by Robert Middlestat on a specific date.
And do you have those?
Well, surprisingly, in preparation for this meeting, I actually went through these files myself again. And for whatever reason, they were not located. For the benefit of Ms. Tsang, I contacted the architect, who happens to be in Rome, who had an assistant go in her office and look through the file and actually turn them up. So just yesterday, I was able to, I actually had those. I actually thought they were still in the box. In good faith, honestly, I thought that all of that information was in here.
So now you're going to give her Bob Middlestat's office is going to get you the assessor's map and the legal description, right?
Well, the information, the last couple items that she is requesting, the faxed information on 6/20/2008, I can provide to her.
You can or cannot?
I can.
Okay. And you can get the rest from the architect?
The other, well, again, what she's requesting is this very specific, the date that I received these particular plans. Those were revision number 11. I'm not aware of revisions 12 and 13 unless they occurred after the planning review. of this permit application. But that specific set of plans have been forwarded to the Department of Building Inspection. They are no longer in my possession.
But you can send her over there where she can look at them.
I did on March 10th.
Mr.
Okay, so I'm just trying to determine, I don't want to take any more time, but she says she hasn't gotten the document. You say you've either given them to her or told her where she can get them. Is that correct?
Yes.
Mr. Yonan, let's talk about what happened forward from March 11th. All right? Never mind what happened March 10th or 9th or 8th. From March 11th forward, that's what we're dealing with here.
Okay.
All right? Now, on March 11th, according to both you and Ms. Tang, you received an emailed request for 5 documents, correct?
Correct.
Ms. Tang said that you have never, to this day, responded to that request.
Because I felt I had already responded to it on March 10th.
Well, but we're not in March 10th anymore. We're in March 11th.
Commissioner, I appreciate that.
Okay. Did you respond to her request of March 11th?
No.
Thank you. Further discussion. All right. Now, at this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. Mr. Yonan, do you have anything further you wish to say?
The Planning Department has repeatedly, in good faith, provided Ms. Tsang with information that she's requested. We have recently, on a separate request, provided Ms. Tsang with yet another file of an exhaustive search of all the emails related to 2642 and 44 Hyde Street. This is after March 11th, separate from this request. We will continue to provide Ms. Tsang with information that is public record and available to us, to her, as we are able to.
Thank you. Ms. Tsang, do you have anything further you wish to say?
Thank you. I'm sorry for my excitement because it has been too long and has been treated really unfairly. My right has been ignored. We have a BBN pay for the planning department. When something submitted to them, we're supposed to be notified. We never get that. He answered you. He did not respond to my 5 requested documents. The document listed 5 documents. I requested. He had no response to that. And to this day, I still don't get it. He can play around the words, what he did. But the fact is that he did not respond with his own word. He did not produce those documents I requested. The building permit, when I requested March 11th, the building permit was not even issued. And the planning department, any plan submit to them, they have the record. They have a file. Even though they submit to the building department, they still have a file. Any other file has one master in planning department's position. Now, you tell me, except this one, what's wrong with this one then? Yes, it's a 10 or 11 revision. Nobody knows what the final looks like. The bottom line is that they did not provide what I asked them on March 11. The previous one, there's more document. I asking for more information. I asking them how are the planning department keep the record, those kind of questions. That's not what I filed the sunshine complaint. March 11 is a 5 specific document they processed. They did not. They admit that they did not respond and they did not produce. Not to you, not to me. Thank you.
Thank you. Matter is back with the task force. Is there anybody who wishes to make a motion on this? Member Washburn.
I don't think I have enough. I really am an expert in planning matters. I don't have enough information to know if he supplied the documents or not. He says he did, or he told her where to get them. She says she didn't.
Okay. Excuse me, Member Cawthon, you were not recognized. I believe Member Washburn is recognized.
Well, Mr. Ionin said that he did not respond to the March 11th request for documents in any way whatsoever because he felt he'd responded earlier. So that's the matter we're considering, and I move to find violation of sections 67.21, 67.25, 67.26, and 67.27.
Is there a second? Moved and seconded. This time we will take public comment on the motion.
Members of the task force, Ray Hartz. I have been CC'd on a lot of the interchanges between Ms. Tsang and the building department. And I really do believe that you saw a good example of their dealings with her with Mr. Iona's presentation today. He comes in with this big, huge box and says, I believe we've already responded to this because we gave him the documents in the past, and he piles this on and put it out of here. And then when somebody specifically says, well, is a response to what you requested on this date in there? No. Hey. You know, they send him emails, and I've even seen them mischaracterizing her requests as annoying and all these other things, trying to misrepresent what she is doing, which is making a request for public documents, which she is legally entitled to do. She's entitled to do that as many times as she wants. If there are multiple copies and she has serious doubts as to which is the most recent or what she really should be working on, she has the right to request it. She requested them. He admitted that he didn't provide them. He didn't even respond to it. And I think that Member Washburn's motion is exactly on. And I think that it was not just inadvertent. It was a willful violation.
Thank you. Is there further public comment on this matter?
Having been at both planning and DBI today to inspect files that I had requested, I have a certain, and I've been to both departments before seeking to look at files, records. There's a lack of sensitivity to the idea about making files available. In the case of planning, I sent an email yesterday before noon telling the person who's in charge of retrieving files that I would be in this morning and I wanted to look at them. So I showed up and she was nowhere to be found, and my files were nowhere to be found. So I went downstairs and I looked at a file at DBI. It took them almost 2 months to locate because their vendor had misplaced it. And in both cases, I had to fill out forms, name, address, email address, and give them my driver's license before they would even let me look at a file. My request at planning was to see all the records pertaining to a couple of street addresses. They gave me, finally, Ms. Wong showed up. She got me the files. And I asked, when I was finished, I said, where are the enforcement files? Oh, we don't have them. They're with a certain planner, and she's not in today. The point I'm trying to make is that this is actually a challenge to the public when they want to see a record at either of those departments. They make it difficult for you. They put in requirements that they shouldn't. They make you prove who you are and why, almost why you're there. So it doesn't surprise me that this interchange shows we did everything we were supposed to. Here's the big box of stuff. And actually, they didn't give her the public records that she sought. Thank you.
Thank you. Is there further public comment on this item?
Hi, Kimo Crossman. I am in favor of finding a violation on this matter. Let me just remind you what CPRA says regarding copies, exact copies. 6253B says, upon request, an exact copy shall be provided unless impractical to do so. I have been CC'd on a lot of the communications between Ms. Tsang and DBI, and I can tell you that it appears to be a very frustrating process to get the records requested, and I can see why they have strong suspicion to think that they're not getting the final copies that revisions are being made to resubmit and get approvals after variances they find problems with a submission, and so they have to quickly change it and resubmit it. And so I think there's definitely a valid reason for them to ask for the final copy, exact copy of the document. And there's certainly issues with DBI and planning about people hiring expediters to push things through, influential people that want to add a balcony or a garage or cut down a tree in front of their place where they live, and oftentimes it seems to happen even against laws that would otherwise prevent that. So I applaud their activism, and I hope that you'll find a violation. I was surprised that the gentleman spent most of his time talking about zoning issues when the issue was responding to records. And I want to say I'm also concerned that when he said that we try to respond as we can to records, I just wanted to remind him of 6726, which says that responding to public records is a part of the regular job duties of every city employee.
Thank you. Is there further public comment? Seeing none, public comment is closed. Further discussion. Member Coughlin?
I have had a lot of experience with the planning department, so you can say that I'm knowledgeable. But I've been able to get records. Sometimes you really have to push. And if you want to see plans, they do make you give your driver's license. I guess they think you're going to walk off with the plans. But I've been listening to what Mr. Ionin said, and I feel that he really did make a good effort to give Ms. Sang what she wanted. And this is based on my own experience, knowing that you have to have a lot of patience when you go down to city planning to get the documents. So I'm inclined not to find a violation.
Okay. Further discussion. Member Williams?
Yes, by his own admission, we're not talking about, like you said, last week, last year, 10 years ago. We're talking about March the 11th. And he himself admittedly, he did not give her the information. So I agree we should find him in a violation.
Further discussion. Seeing none, roll call, please.
On the motion, Member Snyder?
Just to clarify, the motion is to find violation.
Motion is to find violation of 6721, 6725, 6726, and 6727. Thank you. Member Cawthon?
No.
Cawthon, no. Member Manny, excuse. Member Washburn?
Aye.
Washburn, aye. Member Caneva? No. Caneva, no. Member Wolf? Aye. Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Williams? Williams, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 7 ayes and 2 noes.
Thank you. Mr. Clerk, can we have the next item, please?
Item number 10 is determination of jurisdiction on complaint filed by Majid Crawford against the City Attorney's Office for allegedly not providing public information.
Okay. Is Mr. Crawford present? Yes. Well, please approach the microphone, sir. Thank you for coming. You have 5 minutes.
I wanted to give a copy, just a copy of the email. So basically what I asked from the city attorney's office, I'm just going to read it. What is the current and complete policy of the office of the city attorney regarding the following? City attorney policy as it relates to providing services to other city departments as it relates to any city attorney staff or contractor reviewing, commenting on, advising, co-writing, and or writing completely the following: a request for qualifications, request for RFPs, and or IFBs. Please indicate the following specific information. Is there a set fee that the city attorney charges other departments for the above-mentioned services? B, is the fee ever on a case-by-case basis? C, is the fee based on a % of the size of the project? D, are different departments charged differently? And or E, is the fee based on the amount of hours city attorney staff or contractors work on a project? That's the first question. And the question is basically, what is the city attorney's policy? I'm not asking for any specific information regarding our request for proposals, so I don't see how it could be attorney-client privilege, because I'm not asking for any specific information. The other thing is, if the city attorney doesn't have any policy, then they're keeping inadequate policies. And then the second question is, what is the pertinent information and dollar amount of the last 20 times the SF City Attorney Office charged a fee to another department for providing any services related to an RFQ, RFP, or an IFB? Please include the following specific information: pertinent information relating to each specific fee for service, the date the fee was issued, the specific dollar amount of the fee, what is it at RFQ, RFP, IFB, and the department being charged a fee. Again, I understand I'm not a lawyer, but just in my opinion, it seems like what one department charges another department wouldn't fit into attorney-client privilege. It seems like the content of the RFP is what is under attorney-client privilege. And then finally, in the last part, I didn't know. I said, I do not want any information that breaks attorney-client privilege or the law. Please provide all the pertinent information I am requesting within the legal limits. If this requires that some questions or parts of the questions must be answered or partially, then please provide what you can. And the last 20 times that the city attorney received a fee for that service, if they don't keep a record of it, then I'm aware of the unusual circumstances where the city attorney could request additional information to look the information up. But I do think that the city attorney should have a database, and it should have some kind of way to frame the question where it could print out something. And I'm willing to look through more some information if they could just give me what the codes are so I could find it. But I just don't see how the city attorney don't keep records. If Parks and Recs, if they charge Parks and Recs $50,000 for RFQ, or to write an RFP or revise it, then there should be some record of it. And I think it's important that the community knows what departments are being charged for what services. So that's my complaint. They didn't give me any information.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, is the city attorney's office present? Please approach. Thank you for coming. You have 5 minutes.
Yes. Good evening. Congratulations to the newly sworn-in members. My name is Jackson. I'm with the Office of City Attorney. I'm the Public Information Officer. We received the request originally was on February 9th, and we actually did not get that specific request. What we got was a follow-up on February 25th, so there was that glitch right there. What the requester asked was, as previously stated, we responded by just as before, as the first request dated February 3rd, that we do not have documents responsive to his request. We do not keep a list or logs reviewed of documents or RFPs reviewed by the office. To the extent also these RFQs come in, a lot of the comments made by the city attorney, the deputy city attorneys, those are exempt from disclosure because of attorney-client privileges. And I think that the question is so broad. We do, of course, have a billing system, but each of the billing system. We do have, of course, have a system in terms of billing, and like a private law firm, we bill the hours that the deputy city attorneys work on back to the departments that are clients that we're working with. And I just want to bring up, I think. There's a point of clarification. During the committee hearing over jurisdiction on April 20th, Mr. Crawford had brought up that he really had more questions relating to the project that he might be involved with, which is the Fillmore substation project that is part of, that he's working. The project is part of the mayor's workforce economic development office. And after that hearing, I approached Mr. Crawford, emailed him saying, your request was quite broad. Can we help you in trying to figure out what exactly you might need? Because at the hearing, he had said that
our office was charging his particular community project way too much money, and that was not the case. And what I want to share with the members today is that our office went above and beyond and I contacted the deputy city attorneys that are currently working on this project, and actually we have not even drafted an RFP based on this. This means that we have no information to the cost of this work since we have not prepared the RFP for the Fillmore Muni Substation project, which Mr. Crawford had mentioned at the previous hearing on April 20th. Let me know if you have any other questions.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, matters with the task force. Member Wolf.
Mr. Song. So I'm looking at Mr. Crawford's request of February 9th, where he first thanks you for an informative response, and he's now changing his request, which I believe is what is before us today.
Mm-hmm.
So in part one, he specifically is asking for, based upon, as you had testified, that you have a billing system, and he's asking specifically what you are charging the other departments, or charging departments like a private firm.
Mm-hmm.
And you can call any law firm, as you know, and ask them what their rates are, like going to a mechanic. So so that's the first, if you answer that question, if you can. I mean, is that information, did you provide him with that information?
We did not provide that information because part of his part one question, it included specific information that would have violated.
Can you point out where that is?
It was underlined
in
his question? It was underlined in part one. Underlined. Please include the following information. Is there a set fee with departments? Is there description? I think.
Well, let's start
yes.
with A. Is there a set fee that the city attorney charges for other departments for the above mentioned services? Is that not already public information somewhere?
That is, and we have a billing protocol that we can share, and that has.
Have you provided him with that information?
That has not. No.
Okay, let's go to B. Okay, B is the fee ever on a case-by-case basis?
That I am not familiar with.
Okay, so you don't know how you bill. You don't bill on a case-by-case basis?
I would have to consult with my colleagues. They did not provide me with that information.
So you have no knowledge of this information?
I do not have knowledge.
Okay. Is the fee based, C, is the fee based on a % of the size of the project?
I do not believe that is the case. You
don't have to answer the question to me. I'm asking, have you provided Mr. Crawford with that information?
No.
Okay. All right. That's all I have for right now. Thank you.
Before we proceed further, I have a little bit of a point of order, and I apologize for this because I should have spotted this. We didn't vote on jurisdiction of this matter, so it's my mistake. I began by calling the complainant and then the respondent to begin discussing merits. Nobody has contested jurisdiction. Member Knebber?
At the committee meeting, we actually found jurisdiction on this matter too. So
okay, so
I move for jurisdiction. Did you move? I'll second.
Moved and seconded. Is there public discussion on jurisdiction? Seeing none, roll call, please.
On jurisdiction, Member Snyder?
Aye.
Snyder, aye. Member Cawthon? Aye. Cawthon, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Member Chan has had to leave.
Chan excused. Member Johnson?
Aye.
Johnson, aye. Member Williams?
Aye.
Williams, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Again, my sincere apologies for the mess up there. There were, I believe, Member Snyder had the floor next.
Yeah, Mr. Song, I'm trying to disentangle what emails were sent and what emails were answered, and So let me ask a couple of questions along those lines. It looks like there was an email sent sometime before February 9th, which you responded to on February 9th. And then Mr. Crawford responded to that February 9th email by asking a second set of questions, which I think are the questions that are before us today, the questions that Member Wolf just asked you about. Is that chronology correct?
That is correct. February 9th, there was an immediate request that came in, and we responded right away. And then there was a follow-up from Mr. Crawford. And that one, there was the lag. We did not receive that email, but Mr. Crawford followed up on the 25th, and we answered that right away.
Okay, that's you lost me there somewhere. I don't know if anyone else is not following, but I don't. Where is the 25th email? Is the one that I don't see anywhere. Okay, so it's just not in the record. Is that what I'm?
Through the chair, I believe
Member
what they're
Knebber?
saying is that they just kind of left it out, but it's just asking the same question again.
I see. So, but you did receive the questions that Mr. Crawford listed, part one, and then he has numeral one in parentheses, and he asks, what is the current and complete policy of the Office of the San Francisco City Attorney, et cetera. You received those questions on February 9th, right?
Correct. And those were internal documents, and it wasn't until that we right after the hearing on the 20th of April that I went back to the office and tried to find out, do we have any documents responsive? And I asked my colleagues again, and that's what we have produced, that we are able to share this with the public.
Okay, but you receive again. I'm still a little lost. The questions that we have before us, part one, numeral one, part two, numeral two. You got those on February 9th, correct? You received those questions from Mr. Crawford on February 9th?
We did not receive those, but Mr. Crawford said that he did send them in. And
when did you receive those questions?
We received them on the 25th.
Did you respond to those questions after the 25th?
Yes, we responded right away.
Yeah, okay. The handout you...
It looks like you responded to the original set of questions again.
No, we know that. We responded to the separate, updated.
Okay,
Mr. Crawford had changed a little bit of his questions, and we responded right away.
So you responded on February 26th to these questions. I can see from the handout that you gave us. Okay, I think I'm straighter than I was before. Thanks.
Okay. At this time, the respondent and then the complainant will each get 3 minutes to make any concluding or rebutting remarks. Mr. Song?
Sure. I think their bottom line are, from our office, there are two things. That one, we do not have responsive documents to Mr. Crawford's request because a lot of them touch upon on this attorney-client privilege without revealing. We work directly with the different city departments, and these RFPs come in. And we also want to add that we rarely write complete RFPs and RFQs. All the RFQs are also available on the Office of Contract Administration, Bids and Contract. They're all online. And secondly, I want to also add that the request that first came in was really broad, and I really tried to help Mr. Crawford kind of hone down to exactly what his intent and perhaps request was so we can better assist him. We do have an internal billing system, of course, because we work with different city departments. We bill it back to them. However, it takes a lot of time and effort to find out exactly which were the last 20 that came in. We were trying to figure out if there's a particular department that he was looking at that we could better assist instead of just looking broadly citywide. So that's kind of where we're coming from. However, I do want to say that today I've contacted and consulted with my colleagues and the deputy city attorneys, and we do have something that we believe could probably answer the first question regarding our policy in terms of billing, and it's a billing protocol, and I have a copy right here I'd be more than happy to provide to Mr. Crawford.
That concludes your remarks?
Yes.
Thank you. Mr. Crawford? If you wish, you have 3 minutes to make any concluding or rebutting remarks.
I just want to say that I did send this off a long time ago, and just to find out that he had a billing system I'm actually bothered by that. And a lot of things he said isn't relating to my question. I mean, I said in my letter that please disregard the first email. I did thank him because it was a little broad, but I narrowed it to a point where I feel like it was answerable, obviously. And then for him to talk about it's just I'm sorry, it's just I don't he's not responding to any of the questions I'm asking. I think I asked him really clear questions. He didn't respond to it. He's coming today with a billing system. I'm actually offended that he brought it to me here today when he sent me a weird email just a couple of days ago, and it was like it didn't say he was going to give me the information. He just said I didn't even print it out because it was just I'd said, well, it's only a couple of days till we're going to be at the Sunshine Commission, so I'd just rather deal with it there. But it sounded like he was saying something like, I don't agree with what you're saying. Just basically said he didn't agree with what I was saying. I was like, well, I don't want to talk about it. I'd rather just do it at the Sunshine Commission. So I'm really asking that you find him not providing the information, and then for him to bring up the reason why I even brought it up because there's a building in my community, and I was it's been abandoned for 30 years. And so when I found out how much they were charging to do the RFP, it was like astronomical number. So I was like, okay, well, that's strange. That's the big number. So I was just trying to find out. I sent them such a polite letter. I'm just curious to know, because if there is because the Fillmore neighborhood, as you know, I just wanted the information. That's all. I feel like the letter is clear. He said he has something. He just bring it today. He never brought the billing. If he just emailed me just recently, he should have said, I got a billing system. He didn't put that in the email. He said something like he didn't agree with what I was saying. So I just ask that you find him guilty of not providing information, because I think it's really important for me as a citizen that we get this information, that we hold these offices accountable, and that there's transparency, and that, thank you very much.
Thank you. No, you've done that. Member Knebber.
For this, I definitely, from hearing both sides, I definitely think that the city attorney's office had a document, basically their billing system, that would be responsive to part one. Part two, I could see be more in depth because that's parsing through the information. But part one would have been answered. All those questions would have been answered if you just had a copy of their billing policies. Part two is to me is a little bit more troubling, a little bit more difficult, something to look into. So I do think that there is a violation here, and I think it's about withholding. I think 6726, and I would be open to make a motion, but I want to hear some more discussion first.
Okay. Member Wolf?
Yeah, I would agree, but I would also include 6727 because I don't think his response was responsive to the questions of the complainant. And 6721, there was no real written response. It's requested by the complainant. I can go either way on 6721.
Member Knebber?
I would agree with the first part, but I do think there was a response, even though it was a minimal response. So I would disagree with 6721, but the other one I would follow.
All right, so I'll move violation of 67.26, 67.27.
26 or
26 and 27.
And I second that motion.
Okay, moved and seconded. Is there public discussion on this item? Public comment.
I'm a little confused on the timing agree with Mr. Snyder because there was a response on February 9th from Mr. Song, so they must have received something on or before that date. But the city attorney's office has a practice of rejecting records requests, claiming typically the attorney-client privilege in the work product doctrine. It's not really a privilege. In the case of this request, clearly the entity that the service was provided for, that's certainly not protected under either of those. Can't be. Which government? Okay. The nature and description of the RFP and the project, that's a little dicier because they have to show the communication and the whole thing. So I think that there's more to it than just it's covered by the attorney-client privilege or the work product privilege doctrine, because work product is actually two different rules. One is the absolute rule, which is the lawyer's thought process and so forth. And then there's the conditional rule, which says you've got to justify why this particular work product, if, for example, they ordered out a survey from a third party as the attorney for a client, that might or not be disclosable. So you'd have to parse through that. As far as the other claim exemptions, I really don't want to talk about that because I'm not that familiar with them, but those two are the ones that I see all the time. So I think a proper reply could have been, well, if you want to take the airport, we know that the deputy city attorneys who work on it because they're part of a particular group, just like the government group is Zarefsky, it's Mr. Trent, you name it. They could have isolated that group and said, okay, if that's the group that the department you're interested in, then we can probably get together, pull together the time. As for the other information, we would have to parse it and decide which exemption applied. So I don't think there was a good faith effort, basically, to deal with it. I think it was just the old buckshot attorney-client. I don't know what 954 is. Maybe Mr. Snyder knows. That's my point. Thank you.
Thank you. Is there further public comment on this item?
Came across him well, as has been pointed out earlier. If a record isn't directly accessible under 6721C, a custodian of record, when not in possession of record requested, shall assist record in directing request to the property office or staff in getting the information. Also, there's a provision under later on that talks about withholdings, and it says that if you have to withhold that record, then they can ask for more information about the request and try to find, recommend other ways of getting that information. So I would say that there hasn't been an effort to try to assist the gentleman. They clearly have a billing system, and I don't understand why they can't run a version, searching for RFP advice that they've given and so forth. So again, I think they should find a violation.
Thank you. Further public comment?
President Nee, Commissioners, that's what this commission is all about, helping us get public records and information. And I agree with your findings. Thank you.
Thank you. Further public comment? Public comment is closed. Member Snyder?
I don't want to unnecessarily muddy the waters here, but I just want to weigh in. So we have three sections that are before us that I think are potentially relevant sections of the ordinance: 6721, 6726, and 6727. And I think there's a motion for all three of those.
No, the motion is just for 26 and 27.
Okay, so I'm going to definitely muddy the waters. I apologize. I don't actually, in my opinion, I don't see a basis for a violation of 26 and 27, but I do see a basis for violation of 21. 26 to me, I read 26 as being, the issue with 26 is withholding kept to a minimum. That's an issue mostly about redaction, and it's about the choice that the agency makes to withhold portions of a document. 6727 is about whether the agency provided justification for withholding. The agency did respond, and they did provide a justification. As it turns out, it looks like that justification may not have been the right one, but I'm not sure that's the right section to hold them in violation of either. 6721, however, requires that a response come within 10 days, as soon as possible, or within 10 days following the receipt of a request. I think this comes closest to getting at what the problem here is, which is that the city attorney's office did not respond until well after Mr. Crawford made his last request. They're responding, as far as I can tell tonight. They did respond, but they responded incompletely. So it's an incomplete response and a tardy response, and in my opinion, 6721 is the right basis to find a violation.
Okay, do you wish to offer a substitute motion?
And I would offer a motion to that effect, finding a violation for 6721.
Only?
Only.
I'll second
Okay.
that.
Moved and seconded.
No.
Okay. Is there public discussion on the substitute motion? Seeing none, public comment is closed. Discussion? Member Wolf?
Yeah, I will have to disagree to that. While I agree that there is some factor of 6721 in there, and I'll agree with Member Snyder's rationale on it. Absolutely, 6726 is a provision that needs to be in this motion, and 27. 26 definitely, because every department has internal policies, and that's all this is asking for, and it's right in the first sentence. And when you read it through, looking at the key word, which is what is the current and complete policy of the office of city attorney regarding to the following. He's not asking for any particular information. He's just asking for the policy of the office, which, by admission, answering that they have a billing system, that's all I needed, because everything else after that flows right with it. Of course, they'll have a policy regarding how they deal with RFPs and how they deal with all kinds of legislation and all kinds of documents. So we can continue the discussion with the city attorney's office to determine what other policies or how they may handle certain things on a general basis when they come into our office. So I think that the policy was withheld, and I think it was withheld beyond the minimum. So I definitely see that 6726 does apply. And 6727, the justification for withholding, I don't believe the answer was justified. He answered in the positive that they do have a billing system, which answers to Mr. Crawford's request. Do they have a policy on fee structure? Well, they have a billing system, so yeah. How do they bill? What do they charge? I mean, yeah, we could break out the budget or break out budget proposals. We're just about, hopefully, to pass a budget in the next month or so. But this was a specific request for that particular department. So I would ask, and I would amend the substitute motion to include 6726 and 6727. So I move that.
Are those amendments acceptable to the second?
I'm making a formal motion, asking for a second. It's not friendly.
I don't see that.
Okay, this is not a friendly. Member Cawthon. Member Cawthon.
You asked me a question. I'm not finished
Well,
with my answer.
we're dealing on a matter of procedure here. Okay, there is a motion to amend the substitute motion. Is there to include sections 6726 and 6727? Is there a second?
A second.
Okay.
Point of clarification. Can I ask clarification?
Member Snyder, then Member Cawthon.
Okay. So your motion now has a violation under all three of those sections?
All
Okay.
three.
And that would be amending mine. All right, got it.
Yes.
All right. Member Cawthon.
I don't agree. I think that I think there was a violation under 67.21. I do think that there could have been some document that was produced that talked about the fee structure. I don't see it as a violation of the other two.
Okay. Member Johnson?
I have to agree with Member Wolf that 67.26 doesn't necessarily deal with only redaction. It specifically says no entire document will be withheld. And I think that the fee, if there was something on it that they thought was privileged, could have been redacted and the fee left in place. I think it's just the opposite of how you had originally stated it. And they did respond. 67.221 seems like they did respond, but it was in violation of the other two. So,
Member Williams?
Yes, this is just a comment. Mr. Crawford, I do not know you, but I know what you're talking about. And I want to commend you for coming in here and so eloquently as a layperson and presenting this. This is a subject for people of color that has been handling. And for you to address it, you have been the only person that has addressed this issue. And I want you to encourage you and to applaud you, because I know what you're talking about and what's going on in our communities. So thank you very much. You go ahead. Be strong.
Okay, further discussion. Is there public comment on the current motion, which is to find violation of all three sections, 67.21?
It's on the amendment. We have to vote on the amendment first. I'm amending the new motion.
Okay, we need public comment on the amendment, don't we?
On the amendment, yes.
On the amendment. I'm sorry? No, sir. Public comment on the amendment.
So will there also be public comment on the motion as well? I'm confused.
Please proceed.
Okay, so the procedure is I made the original motion. It was substituted by Member Snyder's motion. I amended now the new motion.
I think the amendment returns it to
The amendment
original
returns it
motion
actually
was.
to the question of finding violation of all three sections.
Yeah.
Right.
So in
67.21, 67.26, 67.27. The original motion was just two, without 67.21. Okay.
Through the chair. So those two are still on the floor.
Those two are
Right.
again on the floor.
26 and 27, and then 21, 26, and 27.
Right. Okay. Is there any public comment on the amendment to the motion, even though I can't pronounce it?
Just a point of information, or
Member Washburn.
point of procedure, actually. Member Cawthon did not accept Member Wolf's amendment. She doesn't have to?
No, we're putting it to a vote.
Okay.
So you're asking for comments on adding those two, 67, 26, and 27 to the motion for 67, 21?
Correct.
I think that should happen. I think, as Mr. Wolf and Ms. Johnson said, 6726 includes the entirety for documents. And I think the one thing that's been missed on 6727 under justification for holding, it says when a record being produced contains information, most of which is exempt from disclosure, the custodian shall inform the requester of the nature and extent of the non-exempt information and suggest alternative sources for the information requested if available. So again, there's a duty to assist. So that if for some reason some record had the information you requested but it was completely unproducible, they are still required to suggest alternative sources for the information requested if it's available. And I don't see that they did that as well. Thanks.
Thank you. Is there further public comment? Seeing none, public comment is closed. On the amendment to to Member Snyder's motion, the amendment adds to Mr. Snyder's motion the inclusion of 67.26 and 67.27 to the list of violations. Roll call, please.
Before we do
Mem-
roll call?
Member
I just want to
Knebber.
make sure that we understand what's going on. So first, we're going to vote on the amendment. If that passes,
Then we vote on the amended motion, which is to include, which would include all three.
okay, and then, but what about the original
The original motion would then be,
third?
this would supersede the original motion.
But if this fails, we go back to the original motion.
That's correct.
Okay.
Roll call, please.
On the motion, Member Snyder?
Nay.
Snyder, no. Member Cotton? Cotton, no. Member Washburn?
Yes.
Washburn, aye. Member Knebber?
No.
Knebber, no. Member Wolf? Yes. Wolf, aye. Member Chan? Chan, excuse. Member Johnson?
I'm sorry, this is only on the amendment?
Correct.
No.
Johnson, no. Member Williams? Williams, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 4 ayes and 4 noes.
Okay, the motion is defeated. That takes us back to the substitute motion that Member Snyder had presented to find violation of only Section 67.21. Is there further discussion on that motion? Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cotton? Cotton, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
No.
Knebber, no. Member Wolf? Wolf, aye. Member Johnson?
No.
Johnson, no. Member Williams? Williams, aye. Member Nee?
No.
No. Mr. Chair, we have 5 ayes and 3 noes.
Motion fails. That takes us back to the original motion to find violation of sections 67.26 and 67.27.
Mr. Chair, point of procedure, is it appropriate for me to amend the original motion? I mean, to my own motion.
You may amend your own motion.
So I would like to include 67.2021.
Okay, there is a motion to include 67.21 in the original motion. Is there a second?
Are you doing a friendly? Are you?
Well, I made the motion.
Yeah.
So
So if the second approves, they could
Right.
do it without the vote, right?
yes.
Right. Is that correct through the chair?
Oh, boy.
I believe through the.
It's the round robin of Robert's rules.
No, I actually through the chair, I believe that is true because if he made the motion, if the second accepts, then it's a friendly amendment.
Okay. Second accept?
Who was the second?
I accept.
Okay, so the motion now reads to, and the motion is now to find violation of section 67.21, 67.26, and 67.27.
Mr. Chair?
We have to vote on the amendment.
Member Knebber?
No, we don't because of the friendly.
Oh, sorry.
I would still like to propose a motion that just does 26 and 27. I don't know if I can still do that, but I would move that we just do 67, 26, and 67, 27.
Would you like to move for a separation?
I would like to move for a separation.
I would like to hear the comments around that.
I will explain. It's what I said before. I believe that they did make a response. We might not agree with it, but they did respond to it. So I would not agree that we can find violation of 6721.
Okay. My concern about 6721 is that it wasn't timely. That's the reason for 21.
Okay. I did not hear the complainant complain of that. The original documents only showed us 9th and would come back, and I did not hear in the complaint. It's not about the timeliness, and there's a lot of stuff that happens. So I understand where you're coming from, but I still have to respectfully disagree and say that I can't vote on 6721.
Okay. Member Washburn?
And I tend to agree with Member Knebber that the district attorney's or city attorney's office said they didn't get the February 9th email, and that they then responded right away when they got the second one, and the complainant wasn't complaining about the timeliness of the response. And I think, the bigger issue here is that these documents weren't produced, and there wasn't adequate justification. So,
Member Wolf?
I'll concede. I'll concede to that. That's fine. Convince me.
Has
All right.
somebody, will somebody
So
second
we-
my motion to separate the motion?
I second.
Without objection, motion is separated. We will take first the motion on sections 67.26 and 67.27. Roll call, please.
Public comment.
No, we've had plenty of we've had plenty of public. No, the original motion we already had public comment. And that's what we're doing now. On 6726 and 6727, roll call, please.
Sorry, this is a motion to find a violation of those two.
To find violation of those two.
On the motion, Member Snyder?
Nay.
Snyder, no. Member Cawthon? No. Cawthon, no. Member Washburn?
Yes.
Washburn, aye. Member Caneva?
Aye.
Caneva, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Williams? Williams, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes and 2 noes.
All right, and on the motion, roll call, please, on the motion regarding 67.21, violation thereof.
On the motion, Member Snyder?
This is to find a violation under only that section, right?
Only
Yeah.
67.21.
Snyder, aye. Member Cawthon? Cawthon, aye. Member Washburn?
Aye.
Washburn, aye. Member Caneva?
No.
Caneva, no. Member Wolf?
No.
Wolf, no. Member Johnson?
No.
Johnson, no. Member Williams? Williams, aye. Member Nee?
No.
Nee, no. Mr. Chair, we have 4 ayes and 4 noes.
Motion fails. On the referral of matters on the violations 67.26 and 67.27, that matter is referred to the Compliance and Amendments Committee. Also on the previous complaint, 10015, Tang versus Planning Department. That also is referred to the Compliance and Amendments Committee. Mr. Clerk, would you call the next item, please?
Item number 14 is determination of jurisdiction on complaint filed by Ray Hartz against the Rent Board for allegedly violating 67.24.
Okay. Is there a motion on jurisdiction?
I move we find jurisdiction.
Is there a second? Okay. Discussion?
Chair Nee, we had this in front of us at the complaint committee and we found jurisdiction, so I urge that we find it here.
Okay. Is there public comment on the question of jurisdiction of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Snyder?
Aye.
Snyder, aye. Member Cawthon? Cawthon, aye. Member Washburn? Washburn, excuse. Member Caneva?
Aye.
Caneva, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Williams? Aye. Williams, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Mr. Chair, we have 8 ayes.
Thank you. That takes us to the merits of the case. Mr. Hart? Thank you for coming, sir. You have 5 minutes.
Members of the task force, if you haven't realized it by now, my name is Ray Hartz. If you want to follow, the very first thing I'd like to acknowledge is the 2 people that I have dealt with at the Rent Board. The first is Delenn Wolf, who is the executive director and, as far as I can tell, the most senior employee, city employee with the Rent Board, and also Tim Lee, who is an attorney who works for the Rent Board. And if you would like to follow along the kind of path, look at the very last document that I submitted in your packet for this matter. You'll see that I filed a immediate disclosure request on January 21st of this year, asking for specific information related to a specific employee. And I used the format taken strictly from Section 6724, which says public information that must be disclosed. Now, I will tell you right up front that there was an inadvertent typo. There was a not in there, and they made much ado about nothing. by trying to imply that I was asking for information that I was not entitled to have and which should be redacted. I was never asking for it, and I'm not now asking for it. On January 22nd, I got the response. I immediately noted several areas where I felt it was incomplete. And on April 10th, I filed a sunshine complaint. On April 20, I had a conversation prior to the rent board meeting on that date with Delenn Wolf, who is, again, the executive director, in which I specifically identified to her the two areas I felt were deficient. Number one, 6724, subsection 4, the exact gross salary and city-paid benefits available to every employee. What I received in response to that was a one-page chart that shows all of the salaries for any city attorney in that category. So it was not responsive to his exact salary and in no way answered his city-paid benefits. So basically, this was not responsive. And as I said, these are two intelligent people who knew what they were giving me, and they knew that this was not responsive to that specific request. I also raised questions with her about section 6724, subsections 1 and 2, which asked for a lot of professional information related to that individual. And the immediate response I got from Ms. Wolf was, the city attorney has advised us that we have given you everything we have to, which if you check the package, is one page, which in no way answers about 70% of the material in 1 and 2, especially time with the city, professional, we can go down the list, but I don't think it's necessary. Now, when I got the response from them to the complaint dated April 28th, it says there in part, quote, he does not specifically state how the rent board's response is insufficient. Well, at that point, I said, okay, they have gone back. She said, well, maybe we can give you this information. I did clearly tell her the two areas that were deficient, and then I get this letter. May 11th, there was the SOTF complaint meeting, and they again reiterated we really want to help him. May 18th, we had a second rent board meeting where we were all there, and they did not approach me. And then May 18th, May 18th, they also, which I didn't get until the following day, gave the supplemental response, which again reiterated, quote, the rent board does not know what other records the requester seeks. Okay? Now, you might want to not take my word that Delenn Wolf and I had the conversation, but one thing you cannot deny is that Delenn Wolf, Mr. Lee, and I were in the same room for two rent board meetings and for the hearing. They had my name, my address, my telephone number, and my email address throughout this entire process. And as I think I said before on the other case, when you get a complaint, you know the person has a problem with what you've given them. And at no time have they ever, at one instant, other than what happened with Delenn Wolf at that very first thing, made any attempt to clarify and give me the additional information I requested. Now, as far as sections 1 and 2, there's a lot of information there based on, length of time with the city, length of time, other positions that are held, et cetera, which this is the government. Every time they make a change in his personnel status, they have a piece of paper that justifies it. Step increase in pay, time in service, whatever it happens to be. So there are documents that would be answers to this, but they have failed to produce them. And again, I would like to reiterate that we're talking about the executive director of the rent board and an attorney that works and advises the rent board, and both of them are presenting throughout this that the 5 minutes, the answer that they have given us was responsive when they know fully well it was not.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you for coming, sir. You have 5 minutes.
Chairperson Nee, members of the task force. My name is Tim Lee. I'm a senior hearing officer with the San Francisco Rent Board. I don't think there's any question here that the Rent Board timely responded to the immediate disclosure request. The issue is Mr. Hartz had some objections to that disclosure response, but he never told us what they were. We've been trying to find out from him what they were since the day that we issued that. He basically files a task force complaint. Again, he doesn't specify in the complaint what problems he had with the rent board response. We go to the complaints committee and specifically ask at the complaints committee, both in our written response and in our oral presentation, what is the nature of the complaint that he has about our response. He declines to respond or say anything or provide any more information. So we still don't know what he's complaining about until his response to this committee meeting itself tonight. For the first time then, he tells us, oh, you didn't give us the exact gross salary of the hearing officer that he's looking into. That is true. We didn't give him the exact gross salary, but if he had told us that's exactly what he wanted, we could have gotten it. The rent board does not do its own payroll. The administrative services does payroll for the rent board. After we got his response, we asked administrative services, what is the dollar amount of Mr. Berg's, the hearing officer's salary? They responded in an email to me. That Mr. Berg received the step 14 increment on January 1st, 2010. He'll receive a step 15 increment on January 1st, 2011. And if you look at the document that we did provide that shows the, right at the very beginning, that shows the ranges that we did have in our possession, that has the step increases, that does provide you with the exact salary if you know the step. And I can provide that. I mean, it's right there, and I can state it publicly if Mr. Hartz wants that or if the task force is interested in that. But that provides exactly what he was asking for. We didn't have it until we got it from the admin services. As to the other complaint that he's raising now for the first time, in his letter to the task force, he just identified the exact gross salary. In his comments, he's saying that there's something else about the request that he's not happy with. Now, he may not be happy with our assertion of the right to privacy that our employee has. And I'm not sure. I'd be happy to sit down with him if he thinks that we could work it out, but my guess is that we're not going to be able to work out the right to privacy issue. The rent board is kind of caught between a rock and a hard place. We have, and we acknowledge, we certainly have a duty to disclose public information to the public. But we also have another duty that sometimes conflicts with that, and that duty is not to disclose personal, confidential information of our employees. And we can get in trouble from our employees, just like if we disclose that confidential information, just like we can get in trouble if we don't disclose the public information. So we did the best we could do in providing the information that is disclosable without violating our employees' right to privacy. That's where we are at this point in time, I think.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, matters with the task force. Member Wolf.
Mr. Hartz?
Yes.
Can you reiterate for me exactly what document you did not receive that this complaint is for?
Okay. 6724 is asked for the exact gross salary or exact gross wages and
don't refer to me to the ordinance. Refer to me to what you're looking to get.
His exact gross salary and wages and city paid benefits.
Okay, and that was, I saw it was in the original complaint, yes?
Yes.
Okay.
And I would like to say that he just now is mentioning that he has an email saying that he's a certain step. That was never provided to me, so I basically had a $74,000 range of salary to choose from.
Okay, thank you.
And the second area was in 1 and 2. There are a number of different areas that ask for the length of time working for the city, any other jobs that are held with the city, It asked for the, I don't have it in front of me.
But was that part of your request?
That was a request. I used the exact wording of Section 6724
Right.
with the idea that, hey, this is very clear that you have to give me this information.
Okay, thank you.
I have a question.
Member Cawthon.
Mr. Hartz, did you ask for the video of the hearing? You asked for a tape of the hearing? It seems to me that I'm not understanding exactly what you asked for. Did you ask for audio recording?
Yes, at one point I asked them for any audio recording that existed, and they did answer that in saying that there was no recording available.
So is this part of your complaint?
No, my complaint is specifically about the issues I mentioned, which is 6724 subsection 4, the exact pay and salary, and certain areas of 1 and 2, which referred to his professional, all the stuff that any qualified or any person who's accepted in a position.
Okay, so you're not, because you know since they're not, their position is since they're not a charter body, they don't have to tape their meetings.
Right, and I understand that.
Okay.
Member Knebber?
Yeah, I mean, so the simple idea here is that Mr. Hartz wanted what is enumerated in 6724, and what he got was more general information about the position, not the actual specifics he asked for. I believe the city's position, the department's position is that they didn't understand that, even though, from my understanding, from what I'm seeing, I mean, it is enumerated as it is in 6724. I don't see anything that's saying anything different than that. What he got was the general salary range. He did get the resume or the CV. It looks like that it's an older one, so it was before he had the position, and it doesn't have the information about how long the attorney worked for them. So I am leaning towards finding a violation when it's so moved.
Okay. Further discussion. All right, at this time, the matter is, at this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks.
Members of the task force, Tim Lee for the Rent Board. The two issues, the one on the exact gross salary, we provided the range. The email that he's talking about, which I can provide to you, is from Administrative Services, dated 5/25/2010. They do our payroll, so they can provide the exact information as to where in the ranges, which they did, which he's more than willing to have. As to the other information, I don't see anywhere in his immediate disclosure request where he's talking about how long that you've been working for the city. If he wanted that information, he should have asked for it. We provided the information that he asked for to the extent that the task force, the Sunshine Ordinance required it.
Okay, Mr. Hartz?
Yes, again, to reiterate, 6724 subsection 4, the exact pay and or gross wages and salaries, I think that's very clear. I think what they gave was basically not responsive because it does not tell me either of those issues. In the first two sections, it asks for a lot of information regarding any successful candidate for a position. And obviously, if he's in the position, he's a successful candidate, and I was given 1 page. So we're talking at somebody who makes somewhere in the range of $98,000 to $190,000 a year, and they have 1 page which is responsive to his entire history and what was done when he was hired. Basically, there are other sheets of paper that would give the information, and I could go down item by item, but I don't. You only have 5 minutes. You can't go item by item. But really what I'm saying is I have been talking with Delenn Wolf. They've had several opportunities to talk with me. They could have any time picked up a phone, send me an email, send me a letter, and I would have been more than happy to sit down with them. But they wait, as previously in another case, they wait until here to say, oh, we're willing to do this. And I'll be honest with you. What's the old expression? Fool me once, shame on you. Fool me twice. When Ms. Wolf told me at that rent board meeting that she could probably get me the correct information relating to the salary, and then immediately went into the defensive mode relating to the other information, I took that, especially after reading their subsequent response to the task force saying, we have no idea what's going on, as saying, well, we don't want to bargain over this. And any time, at any of those meetings, did they once approach me and say, would you like to sit down, have a talk, point out where you feel it's wrong, and we'll see what we can do? No, they did not.
Thank you. Matter is with the task force. Is there a motion? Member Knebber?
I would like to actually just make a clarification. From looking over it again, it does not say that it needs to have how long they've worked for the city, but the other things still stand. The exact list salary.
Microphone, please.
Oh, excuse me. From looking over it again, 6724, it doesn't say anything about how long they have worked for the city. It does say years of employment in the private and or public sector, so that's how you wanted to determine that, or how you want to interpret that, I should say. But it does, as Mr. Hart say the exact gross salary and city paid benefits available to every employee.
Okay. Member Wolf.
I thought the complainant was looking for the years of employment in private and or public sector.
Again, that's what I'm saying. I mean, that's open. It doesn't exactly say working for the city of San Francisco or anything like that. It does. You can interpret. I can see that as interpreted as how long they've worked for the city of San Francisco. I'm just saying that it doesn't say that definitively.
Okay, I'm not necessarily in agreement with that. He asked for he just copied it from the code, so he feels he didn't get that information. So okay. Okay. So is there a motion on the floor yet? No?
No, not yet.
All right. So I wanted to, and if people can correct me, there was no audio recording of this?
That's correct.
Okay.
Just through the chair.
Member Knebber.
I just want to make sure that we keep streamlined on this issue, because the complainant those are separate issues that the complainant didn't bring up himself. He was asking specifically about the information about this person, disclosable under 6724. So I know we talked about audio recordings and that kind of stuff, but that's a completely separate issue, and that's not included in this complaint.
Okay.
Member Coffin?
I have some concerns about the exact gross salary. The requirement under 67.24 is the exact gross salary and paid benefits available to every employee, and they did provide a list of the range for every employee. So I wish that Mr. Hartz had asked for Mr. Berg's exact salary, because they say they would have given it to him, but I don't think he did. So on that basis, I don't think there was a violation, not on the salary.
Member Washburn?
I tend to agree. That's how I read that. It's not of each employee, it's every employee.
Yeah. I agree as well. I think it appears to me they made what I think is a reasonable interpretation of that. The exact gross salary and city paid benefits available to every employee. I could see how you could think what that means is give us what every employee makes, and so they responded by giving a scale. I mean, I think if they read the request very carefully, they'd see that it's supposed to apply directly to Michael Berg, administrative law judge. To me, it seems like a reasonable interpretation that they made. And if the complaint had specified that Mr. Hartz had specified in the complaint that he wanted one administrative law judge's particular salary, that might change the equation. But I agree.
Member Johnson and Member Knebber?
I disagree that he did not ask for that. I mean, It specifically said it's regarding Michael Berg, and he says he wants this specifically listed about that particular administrative law judge. So I disagree that it's a reasonable interpretation that he wanted everything. I can understand where you might do that, but since it starts out by specifically saying it's about that administrative law judge, and he actually states it twice, and then lists this to say you're required to provide it as well. I don't think he listed that for it to be the intent that that was the overrode the original request.
Okay, is there a motion?
I move we find violation of 6724 C.
Second.
Moved and seconded. Discussion? Is there public comment on this item?
I think you should find a violation. I just want to say that you're here to interpret the law and to provide justice, and you're supposed to have a bias for the public in getting access to information in public records. I'm starting to hear kind of a parsing of language in the last couple of ones that I'm a little bit concerned about. That that maybe technically something hasn't been violated, but certainly the spirit of Sunshine has been violated. I just want to caution the members about, again, your bias, as Sunshine says, is to be for the public and advocate for the public to get the information they request.
Thank you. Is there further public comment? Seeing none, public comment is closed. Further discussion by the task force. I have one comment. Although it is not part of the complaint, I think the rent board is making a big mistake in not recording its meetings. Under the law, 67.14B has the requirement for charter boards and commissions. However, look further down to 67.14C. There it says, every city policy body, agency, or department shall audio or video record every noticed regular meeting, special meeting, or hearing open to the public held in a city hall hearing room that is equipped with audio or video recording facilities, except to the extent that such facilities may not be available for technical or other reasons. If the rent board meets in a facility where audio recording is equipment is provided, then it must be done. And now you don't even need the audio recording equipment to be available in the room, because there are portable devices out there that enable that, and they're, I don't know how much they cost, but they're out there. I'm sure the city could afford them, and there's no reason not to do those recordings. And 67.14C does not distinguish between charter and non-charter bodies. It just says every city policy body, agency, or department. So if somebody wanted to bring a complaint on 67.14C, they could do so, and I would certainly vote to uphold it.
Chairney,
Member Cawthon.
I just wanted to say, this is something that has been in my craw too, because I think they should tape their meetings, and the lawyers come with their own taping machines. At least they did the one time I went to the rent board. But I think that the charter, one of the things that we're going to change in our ordinance is that we're going to make, we're going to bring charter groups within the rubric of the Sunshine Ordinance. I don't think it falls there, and that's why I think they could get away with not taping. This is not specifically an issue that Mr. Hartz has raised. I just hope that our amendments
Well, that's
pass.
correct. It's not part of this complaint.
But I do hope our amendments pass, and I don't think the authority exists right now to require that just as policy bodies they tape, because as charter bodies they are exempt.
I disagree, but this isn't the place to argue that. Is there further discussion on the motion? Seeing none, roll call, please.
Did you read the motion?
Motion is to find violation of 67.24C.
On the motion, Member Snyder?
Nay.
Snyder, no. Member Cawthon?
No.
Cawthon, no. Member Washburn?
Yes.
Washburn, aye. Member Knepper?
Yes.
Clever, aye. Member Wolf.
Yes.
Wolf, aye. Member Johnson.
Aye.
Johnson, aye. Member Williams. Williams, aye. Member Nee.
Aye.
There are 6 ayes and 2 noes.
This matter goes next to the Compliance and Amendments Committee. Before we go to the next item, I'd like to declare a 5-minute recess.
Anticipating this, so I had a very late, very big one. And I brought snacks.
Do we, as a matter of course, just consider those, or is there any kind of practice saying, no, you're held to the obligations of your complaint? It's been our consistent advice.
Even though I like to.
It's necessary.
Thank you.
I was going to bring that up, I forgot. Tell their side of the story, and if you come in at the last minute, just like when the planning department came here, not having any response. Yeah, that's one of the. It's sort of the other side of the same coin that you do need. I mean, that's why there's a rule in the task force complaint procedures that you have to file anything at least 5 days before.
Well, I wouldn't have gotten it if I had.
No, that's been our advice.
Stopped
So
it.
I say
Mailman.
asked and sometimes when not asked. By the way, but the task force does what it does, so sometimes they honor that, sometimes not. So. Is there anything explicit in the rules that says that it's raised that's not in those materials that have to be here by date certain? Won't be considered or shouldn't be considered? Or is there anything explicit that prohibits the consideration? And I remember that's true about that. My intuition is no, but I can't. I gotta see what they say. Because it strikes me as it's a difficult practice to consider things that are raised for the first time here. Sure. And it's not something that if there were, it would have to be policed by the chair for it to really take hold.
Where's the provision such a
And I can assure you there would be much pushback. I just, anytime the task force tries to what they have to do is go down there and register. Violation of the spirit, and that's the typical attitude the public has about this. I mean, there is some always extra motivation. Yeah. 21 on. They're pretty quick. Yeah, I tend to think there's a good deal less room than members of the public too, but that's the lawyers versus the layperson.
Shocked when the meeting was at 5 because we had all those special meetings. And oh my God, no, it's at 4.
Is this your assigned to this full time? No. In fact, there's a limited amount of time that I'm assigned to it. That's one of the complaints that folks have. Because there's not a full time assigned to the task force. What are you limited to? This year it was 280 hours, although we're now at about 320. And you prepare all the memos? Yeah. I mean, I gathered that from the. So we've had a couple of sort of record hearing nights where we because we had so many complaints, and each one of them got a memo, and some of them are complicated, raising new issues. So you can't really control what comes to the task force, So, but there's only a certain amount of general fund money. So, how does this agenda compare in terms of number of items and length to it? I'd say it's a little bit above average. Faster the first quarter. On many of them, you're doing it at a pretty good pace. A couple of them,
think each of your own impatience is probably going to make you, over time, speed up a little bit.
Allows us to also, especially as I get more familiar with the law.
Well, that's true too. It's not a simple law. That's one of the difficulties.
The meetings I did notice that Eric did a good job of kind of focusing the issues, and you too, focusing the issues on what the issues really are.
Yeah, Erica was probably more effective than me at that because I think there, to some degree, there's a level, certainly in the public, who works on task force.
Well, you're right in the middle.
Our office, because we also advise the other side, of the equation, the departments that are responding. So, I'm not allowed to talk to those attorneys about the complaints, but still people have understandable perceptions.
And you're not, formally a member of the body.
Did you listen to Alan and the ethics?
Yeah, I need to send a text to tell my mom when I'm going to be home.
Sure.
Very interesting. You know, Alan, the project is.
Jerry, I don't need to interrupt. You don't answer letters either. Well, that's okay. You're in good company. You're in good company. Paul Zarefsky doesn't answer letters. Gifford doesn't answer my letters. None of them answer my letters. But it's okay. But I do have a question for you. In your jurisdictional, I think it's on this one. You said that this is jurisdiction. I think that's the one where you said that you didn't think there was jurisdiction, that you were advising them. Your pitch, which one? It was either this one or the one before.
Working my ass off.
Maybe it was the one before. I'm not sure. It was one of them. I want to point out something to you.
So I went to Google
Yeah?
and got a
6725.
Eagle 14.
Says
Nice. This is the Windows machine, right?
No, the Android 4G.
The ordinance.
Still tons of stuff to do.
Nice. So you can watch it. Oh, that's cool.
It's got one gigahertz Snapdragon 5.
Then what happens? What do you do? You do
Video, conferencing, and 8 megapixels. And it's got double LED.
Just keep calling out.
But it's only on screen. On screen.
Yeah. And you know, I've got
So
Have you?
he has two of them.
You feel you can text them. Right? I know. That's true. That's great. I'm not going to switch my plans because I've been
Yeah, I know. I need to. That's why I wanted to love.
That's what?
That's why I wanted to love.
Yeah. With this, I'm on T-Mobile.
Yeah, which I love.
And I'm paying like $50 for.
If you went to a nice.
I had a, but I thought it was more
I've
been friends with Jerry Green on Facebook for a long time, but this first time I met him.
Because I'm a loyalty customer. Yeah. Oh yeah. So I'm waiting for them to come out with the phones.
Yeah.
Yeah. Because the show is over.
Right. The one thing for the same is not something about this because it has the 4G and
Yes, you're welcome.
You can't increase the. Can you replace the battery?
can't replace it. I mean,
See what I did here.
Isn't it though?
But bet you they'll figure out a holster with a battery. So sorry. It's nice that they have the headphone, right? That's good.
Okay. And he's been here.
Yeah.
Preaching.
I'm just starting my third year, and the first year I wouldn't have said anything. Yeah, I just what was going on. I really didn't.
Yeah. And if you've got your laptop, you can.
So it really takes a while. It takes a good year. Yeah. It's really good for me.
Did I have to what? No. I just
But I saw that
downloaded
you were
this
in an
little
MPA
application to Tether. That's all. And I had to do it safe.
No, when you're sitting there, they are not. That's not true.
I don't have this registered.
Actually, I think that's absolutely right.
But that was 5 years ago, too.
Rick, I think that's absolutely right.
Jerry.
We are back in session. Again, thanks to everybody for your patience and endurance. Mr. Clerk, could you read the next item, please?
Item number 16 is determination of jurisdiction on complaint filed by Ray Hartz against the Rent Board for allegedly violating Section 67.16 of the ordinance.
Okay, Mr. Hartz, please approach the microphone. Again, thank you for coming, sir. You have 5 minutes.
This is on jurisdiction.
Oh, jurisdiction. I'm sorry. If you wish to comment on jurisdiction, I apologize. This is on jurisdiction. Is there a motion to accept jurisdiction?
I move we find jurisdiction in this matter.
A second.
Moved and seconded. Discussion. Is there public comment on the question of jurisdiction?
Actually, before we do that, I would like to say we had found jurisdiction in the complaint committee, but since then, our Deputy City Attorney has come back and actually brought up a good question about jurisdiction based on 6716, which states, I mean, it depends on how you want to interpret it, but the clause in question is, from the beginning, the clerk or secretary of each board and commission enumerated in the charter shall record the minutes, yada, yada, yada. And then beyond that, it says just generally the minutes shall state, written summary, that kind of stuff.
Okay. Perhaps we want to hear then from the parties in interest.
Yes.
Okay. Mr. Hartz, please approach. This is regarding jurisdiction of this matter.
Yes, I understand that. And I would like to acknowledge Deputy City Attorney Threet's letter because I think he really does look at both sides of it. He says if you read the law one way, then technically, yeah, they're not in the charter and don't have to comply with this section regarding the minutes. However, he said you can also read it the other way. And because of that difference, I would say it's definitely a matter in the jurisdiction of this task force because it is up to you to decide whether or not you have the jurisdiction. Your own advisor from the city attorney's office is telling you if you read it one way, you do. If you read it the other way, you do not. And I think that's an issue only you, as members of the task force, can decide.
Thank you. Mr. Lee?
Chairperson Nee, members of the task force, the complaint here does not allege a violation of the Sunshine Ordinance. The complaint alleges a violation of proposed amendments to the Sunshine Ordinance. You have before you amendments that would make the requirements for charter commissions applicable to non-charter bodies. One of the requirements for charter committees is exactly what he's saying we're violating. If and when you pass those amendments so that we're subject to them, we would be gladly to comply with that requirement. However, it's simply not the law as we speak. He's talking about Mr. Threet's initial letter to the Complaints Committee, since that saying that it could be read one of two ways. Subsequent to that, he's looked into it further, realized that you had proposed amendments to make this very section applicable to non-charter commissions like the Rent Board, and you haven't adopted them yet. And he basically said you do not have jurisdiction, and that if you proceed, you'd be proceeding against his legal advice. So I would submit to you that there is no jurisdiction here. There's a alleged violation of something that is before you as a proposed amendment. Just as an aside, so we don't have to come back, hopefully, with a complaint for not recording our Rent Board hearings. That provision also applies only to charter amendments or to non-charter charter commissions or non-charter committees that are in a audio-visual approved facility. Unfortunately, I think for us, the Rent Board does not have the ability to get into one of those audio-visually set up rooms. We have tried unsuccessfully for a number of years to be able to hold our Rent Board meetings at City Hall, say for instance in this office, and there is no time available for us. But again, so that provision does not apply to us as the Sunshine Ordinance presently is written, and so we're not in violation of the current law either for that provision or for the public comment written summary. Again, if the proposed amendments are passed, there'll be no question that we, like every other commission, charter or not, would have to comply with both of those, and we would we do it with what would be necessary to comply with those.
Thank you. Matters with the task force. There has been a motion to accept jurisdiction.
Honestly, in interest of discussion, I'd like to withdraw my motion.
Okay. Member Snyder?
I was persuaded by Deputy City Attorney Threet's memo, and I just, as a point of clarification, I think he does come down pretty clearly that we do not have jurisdiction here. I think he weighs both sides, and I think did a very thorough job of considering all the possibilities. And I'm persuaded by his analysis that the administrative code just it doesn't apply here in a way that we can take jurisdiction. And I don't think it's up to our discretion to say we're going to go against the code. The code says what the code says, and it may well be amended soon, and this analysis would be different if that happens. But for now, I'm persuaded by Mr. Threet's analysis, and I would say we do not have jurisdiction here based on that.
Okay. Further discussion. Is there a motion to find no jurisdiction?
I would so move.
Is there a second?
I second it.
Moved and seconded. Is there public discussion on the motion not to accept jurisdiction?
Hi, this is Kim Crossman. I would advocate that you accept jurisdiction. All the parties here that are affected by this complaint can present their case. You can always find that there wasn't a violation. Based on the analysis by Mr. Threet, if you find that ultimately the body wasn't required to take minutes, but you have everyone here to take evidence, and so I would recommend. In the past, it's been the theme of the task force to liberally accept jurisdiction, only in cases where it was, very clearly, like if someone came and wanted to complain about a zoning issue here, then that would not be accepted. But if it's something relating to sunshine, the task force in almost all cases has gone ahead and accepted jurisdiction and then heard the evidence and then ruled after that. So I would strongly advocate that you vote no on not accepting jurisdiction.
Is there further public comment?
As I understand it, the complaint committee took jurisdiction until it saw Mr. Threet's opinion.
No.
Which came later.
There was an opinion before that.
Pardon?
This is a revised opinion.
Oh, a revised opinion. Oh, so we didn't actually.
Excuse me. This isn't the time for back and forth. Please continue with your comments.
Okay, my comments go like this. Mr. Threet is a very experienced, but highly qualified attorney. Mr. Hart probably isn't at the same level. I can state quite honestly, I've had many jousts with the city attorney's office where we've disagreed on some very basic stuff. I just had a conversation with Mr. Threet talking about his role here. In any event, if this issue had been presented at the complaint committee, it would have been handled. Maybe Mr. Hartz would have realized he needed a lawyer or some help to figure out what to do. Now, it's too late because the revised opinion has now been accepted at least by one or two people, and he hasn't had a chance to figure out what to do with it. I would be very happy to help him if I could, if he asked me, but I don't think it's fair to him to dismiss the case on the basis of an opinion which somebody like me might disagree with. And I just think, if nothing else, you should continue it or table it for the next meeting. Thank you.
Thank you. Is there further public comment?
Good evening, President and Commissioners. Anonymous tenants here. Is this for accepting jurisdiction?
No, sir. The motion is to not accept jurisdiction.
Oh, I'm against that. I think you should accept jurisdiction, and I think Sunshine is main purpose is to help the people and protect the people. And if there's a discrepancy in the law, then you have to favor the citizens. So I think you should accept jurisdiction. Thank you.
Thank you. Is there further public comment? Seeing none, public comment is closed. Member Kneber, then Member Cawthon, then Member Williams.
I don't agree exactly with the speakers, but I do think that we should find jurisdiction. Because I would like to say it again. The reason why is I think that we do have jurisdiction because it is a sunshine matter. If we find that this body and what it did falls outside of the ordinance, that's a finding of fact. It's not about the jurisdiction. When we talk about the way that meetings are run, the way that information is presented, those are sunshine matters. So in that sense, I think it is a sunshine matter, and I would think that we would have jurisdiction.
Member Cawthon?
You know, I was so certain that that it was a non-charter, that it's a non-charter body, so that matter was moot. But then reading Mr. Threet's opinion and hearing what Mr. Grossman said, I'm not so sure. I do think that Mr. Hartz did not have an opportunity to get some legal advice from some. Mr. Grossman has given legal advice in the past that's been very compelling. So, I would like to read this over again and go over and look at the Good Government Guide and make and come up with my own opinion. I think this thing should be continued so that we have an opportunity to evaluate it more closely, and that for Mr. Hartz to have an opportunity to talk with Mr. Grossman. So I think we've already got a motion on the floor, but I would certainly I would certainly make my motion after we vote on the motion on the floor.
Well, I think if you wanted to, if we approve the motion, then the matter is gone. Yeah. So if you want to make a motion to continue, I would strongly suggest you do it now.
Well, then I would make a motion to continue.
Is there a second? There's a motion and second. Discussion. Is there public comment on the motion to continue? Member Wolf.
Discussion. I don't think there's a need. You have the people here. It's 8:30, a little after. I would say just not cluttering up our future agenda, which might be just as full with taking this and adding it. I would say let's just move on. I think it's worthwhile. I have a pretty pertinent question to ask about this that would come up and would have to be answered then. I'd like to have it answered now because it may affect how we move this forward anyway.
Member Johnson.
I think that we should also move forward with it, and I do think that we should find jurisdiction because I think that the correction, that the potential amendment was to make sure that it was in the spirit of the law, of that particular wording was in error, not because they were never intended to be included. And the rent board, I mean, that's pretty much about the people. So I would vote for jurisdiction against the motion.
Okay.
Member Williams.
The only reason that I said that I would continue, I was listening to see what James was going to say, and when he accepted it at the complaints committee, I trusted him, and that's one thing that the board members have to do, trust in each other's judgment, and I truly trust our city attorney when he gives us any kind of advice. So I would say let's get on with it, you know.
Member Knebber.
I just want procedural clarification. So, say we go through, we have a motion that is to continue with a motion to not find jurisdiction. If I put forward a motion to find jurisdiction, would that be on the table too, and we vote each three in order?
Well,
I would say that first we vote to continue. If that fails, then we vote on the motion not to find jurisdiction.
Then it would still be open. Okay. I was just worried about if we voted on the motion not find jurisdiction, that we would be dead in the water. But I can make another motion after that.
If the motion to find no jurisdiction fails, then the matter is still before us.
Okay.
Is there public discussion on the question of continuing this item?
Yes, Kim Rossman, as I said before, I think you should hear the matter here today. All the parties are here, and I think you can resolve this expeditiously.
Further public comment? Seeing none, public comment is closed. Roll call, please, on the matter for continue.
On the motion to continue, Member Snyder.
Nay.
Snyder, no. Member Cawthon.
Yes.
Cawthon, aye. Member Washburn.
No.
Washburn, no. Member Knebber.
No.
Knebber, no. Member Wolf.
No.
Wolf, no. Member Johnson.
No.
Johnson, no. Member Williams. Williams, no. Member Nee.
No.
Mr. Chair, we have 1 ayes and 7 noes.
Okay.
Mr. Chair, I moved for substitute motion on the original motion.
And that is?
To find jurisdiction.
Okay. Is there a second? Moved and seconded to find jurisdiction. This substitutes for the motion, and it would, if passed, would supersede the no jurisdiction motion. Is there discussion? Is there public comment on the motion to find jurisdiction? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Snyder.
Nay.
Snyder, no. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Knebber.
Aye.
Knebber, aye. Member Wolf.
Aye.
Wolf, aye. Member Johnson.
Aye.
Johnson, aye. Member Williams. Williams, aye. Member Nee.
No.
No. Mr. Chair, there are 6 ayes and 2 noes.
Okay. Motion passes. Jurisdiction is declared. That takes us to the merits of the matter. Again, Mr. Hartz, thank you for coming. You have 5 minutes.
Members of the task force, I do appreciate your willingness to hear this. I think you've probably already discussed many of the issues that I'm going to raise because it's a simple one. On February 23rd, I attended a meeting of the Rent Board, and having been to a prior meeting and read the minutes that they came out with, I found that the comments I made were mischaracterized and wholly washed of any spirit. I decided then, looking at the law, that under 6716, basically the minutes allowed me to put in a 150-word or less summary of what I said at the meeting, and I submitted that to them at that time. Part of the reason I didn't file either of my complaints until April was because I wanted to make sure that they had finalized and accepted their minutes without this addition before they actually I raised the complaint. Basically, the argument has already been made that they're saying they're not a body enumerated in the charter, and as a result, they don't feel they come under this. But I would like to point out several things. Number one is on each and every one of their agendas and minutes, they put down know your rights under the Sunshine Ordinance, but now they come in and they say, oh, well, yes, we follow the Sunshine Ordinance, but not this section, and what other sections don't they follow? And I think the argument is a slippery slope, which really leaves the public in the lurch. Because now every time you want to do something, you read this and it's like, okay, are they going to now come and claim, oh, this part doesn't apply to me and that part doesn't apply to me, and well, this does, but only in these circumstances. So we go round and around and round. I think that there is a basic issue here. One is freedom of speech. And two is the idea that they are trying to keep things from being said that they did not want said. In other words, they're trying to censor people. I got copies of their minutes for the last, for all of the rent board meetings for this current year. And if you compare those to what they have posted on their website, not one of them matches up. In fact, everything that's on their website deletes public comment completely. And I really feel that it is inappropriate, number one, to put on their website minutes which are not actually replicative of what are the improved minutes, especially when they delete all the public comment summaries. So we're not even talking about, they don't want to put the summary, they don't want the 150 words, they don't even want to put the summaries in. Okay? So basically, my position is that if a member of the public comes before a government body, First Amendment rights guarantee I have freedom of speech, and I have the right to petition the government for redress of grievances. Like it or not, the rent board is a member of, or is a part of the government. And I have the right to come before them and say in my own words what it is I want to say, without fear of having them editorialize. Certainly without fear of having them completely mischaracterize and or delete my comments. And I think that it is in the best interest of the public in general, because frankly, I've been attending all the rent board meetings since the beginning of the year, and they don't record anything, and I think there's a very good reason they don't record it, because they say things unintentionally which show the game. At one point, one of the board members said, oh, we already decided what we're going to do on cases like this. And they have a secret agenda. It's called their policies. And you say, well, where are these policies written down? They're not. So basically what they do is you go along and you're fat, dumb, and happy thinking everything's going fine, and all of a sudden say, surprise, policy says this. In fact, I think what it is their policies basically decide the cases before they're even heard. So really, I have some problems with the rent board. I wanted to go forward with this and have it in there, and I wanted to be able to say what I had to say in the way that the U.S. Constitution guarantees. I have the right to petition them when I feel they are in the wrong, and I have the right to say in my own words and in whatever way I feel will be effective in getting them to do what I believe is right without fear or harm in them censoring me or trying to prevent me from saying what I want to say.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, would the respondent approach, please? Again, thank you for coming. You have 5 minutes.
Chairperson Nee, members of the task force, if you agree with what Mr. Hart says, then basically you don't need to do any amendments. You can save yourselves an awful lot of time and effort and just forget about all those amendments, because basically what he's saying is you can just go with the spirit of the Sunshine Ordinance. You don't have to look at the law. You don't have to apply the law. You don't have to let anybody else know what the law requires them to do or not to do. You can just say, let's go with the spirit of the law. I submit to you that that's no way to run a society. That's no way to regulate government or private conduct. Basically, we have laws so that people know what they're supposed to do, what they're not supposed to do. That's very basic. And if you throw that out, there's really nothing left in terms of how one's supposed to conform or comport to what one's supposed to do in life. He basically is alleging a violation of a proposed amendment. Once that amendment's passed, if we didn't follow it, we'd be in violation. The current law does not require it. We are not in violation of the current law.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Wolf, and then Member Cawthon.
Despite the testimony that we just heard, I'm having difficulty with this because in the documents that we have in front of us, it stated that that there was a May 11th jurisdiction letter that was provided to the complaint committee. And I was afraid of this since before the previous term that I served on this body, we had changed kind of the process of how we deal with, matters of jurisdiction and then moving forward with hearing the actual complaint, that we don't get all the documents that you usually would come through from the complaint committee anymore. So I don't have that document. So throughout legal counsel's jurisdiction letter here in front of us, I have absolutely no knowledge of whether the rent board is a policy body or whether it's a charter board. And I'm here right now, this moment, unless we take another recess in order for me to find that out, I would move to continue this. And that's why I said, that's why I would there would be possible monkey wrench. Unless somebody can elaborate and help me out.
Member Cawthon, Member Williams, Member Knebber.
I'm having the same problem. I came in here, I've always thought that isn't it a shame that the rent board is a non-charter body? And isn't it nice that the Sunshine Ordinance is the revision of Sunshine Ordinance would do away with that? However, now I'm hearing that our respected attorney, Jerry Threet, has a corollary argument that would prove that a policy body can extend beyond a charter body. Jerry, could you clarify if I'm interpreting what you said right?
Through the chair, Member Cawthon, I'm not sure what your question is. Can you restate the question?
Is there a corollary argument? We all know there's the argument that the rent board is not a charter body, therefore it's not covered by certain aspects of the Sunshine Ordinance. But did you say you wrote an argument whereby the opposite could apply? Or did I misinterpret that?
No, I think, let me state what the letter was. There was a jurisdiction letter that I provided to the committee when I came back from 2 weeks away under a time deadline, and looked briefly at the provisions of the different provisions of the ordinance that applied here, and concluded that there was some ambiguity there, because although the provision that's in question here says that minutes shall be kept by charter boards and commissions, it goes on to specify what are included in minutes. When I looked at that in isolation, I thought it could be read one of two different ways, that those minute requirements only apply when minutes are kept by charter boards and commissions, or alternatively that those minutes requirements would apply wherever minutes were kept. And I looked at it more carefully when I had more time, and that was unfortunately after the complaint committee had met and acted on the jurisdiction issue. And when you look at all the other provisions that distinguish between a charter board and commission and a non-charter board and commission, there are a number of areas where the ordinance makes that distinction and imposes greater requirements on charter boards and commission. And in that context, it's my conclusion that it doesn't make any sense that this particular example would require minutes to be kept by everyone when all the other examples make that distinction, that only charter boards and commissions, for instance, have to keep these audio recordings. And there's other examples in the memo that I've provided to the task force.
Okay, thank you.
I think Member Knebber had a comment, and then Member Wolf.
So I agree with this argument. I don't agree that it withholds us from jurisdiction, but I do agree that in this case, if we follow the letter of what is written in the Sunshine Ordinance, that we have to find no violation, because there are a lot of places where it does say that it does make specific differences for chartered entities. Now, I think that the spirit says that we want to have everybody to do this. I think that's why we're doing this close revision in these amendments to make sure. But in the way it's written, now I don't subscribe to all these grandiose ideas that society is going to fall apart if we change things or don't have that. But to be fair, I think that we have to follow what is written, follow the letter, and the way we interpret it. So I would have to vote for no violation in this case, even though I find jurisdiction under sunshine.
Member Wolf?
Okay, I still don't know whether the rent board is enumerated, is a board or commission enumerated in the charter.
Mr. Threed?
I'm sorry I didn't clarify that. It is not a charter enumerated board or commission. It's a board that is created by ordinance.
So if that's the case, then we aren't either.
That's correct. We are not.
Okay, so stop taking minutes.
Well, the idea, through the chair, the idea is, again, it's the spirit, and I agree with you. It's the spirit that we want to have this happen, but it's not written.
I understand. Here's my question. What is the regular practice of the day in the city of county of San Francisco? And you do that does have some level of value and gravity of what is the regular common practice of boards and commissions under this dome. And all parties to it. And it is the regular practice of the day, and any court would uphold that, and has, that if there is a general practice, that would carry the day. So I'm a little confused and because I would have to ask the person from the representative from the rent board here, if at any time in the history of the rent board have they ever taken minutes, and if they've ever taken minutes once, okay, then they've assumed that to be somewhat of a regular practice.
Let me make one correction here. The complaint is not whether minutes were kept. The complaint from Mr. Hart is that the minutes of a certain meeting, February 23rd, 2010, did not contain comments of not more than 150 words that he had submitted. That was the complaint, that his comments were not included in the minutes.
And through the chair?
His complaint did not involve the keeping of the minutes.
And through the chair, that is a problem that we've run into with a lot of boards, that and this is things that we have held, enumerated boards, that they have to do this. But the question, by your standard, I mean, a lot of boards don't do this, and I don't think it's right, but I think that it's not. I mean, if we follow what it says here, I do think that it's an oversight, and I think that's something that needs to be corrected. But from what's written, I need to keep going.
I mean, to just turn your argument around a little bit, Member Wolf, just for the sake of argument.
Sure.
If there were if it were practice of the day for city agencies to not provide records, even though the law said that they were supposed to provide records, would we go with the practice of the day and say, well, they don't provide records, so they're not required to, even though the letter of the law says you must provide records? I mean, if the letter of the law says that they don't have to keep minutes, they don't have to keep minutes.
I understand it. I don't necessarily think you can turn it on its head like that. I mean, it's one thing
to make a point.
Yeah, I understand your point. But in my humble experience, in a situation like this where it states that a whole body of bodies would normally take it, and if that one particular body just never ever did it, yeah, they would be in compliance in some way. But the general practice and the fact that the spirit of what we're talking about, even in our amendments, I think that rules the day. The fact is here, it seems like there were minutes taken, correct?
But again, I think that we're getting down to a specific point about the minutes.
Yes.
The specific point here is a 150-word summary.
Yes.
Which we've had a lot of problems with other boards about doing this. So it's not something, and I'm not saying they're justified. It's just, so if you're talking about the practice of the day, I'm saying that it's not been, we've been trying to get that to be.
Gotcha.
And if you're looking at this as the way it's written, I could see it interpreted as we don't need to do it. I'm not saying it's right. I'm just saying that we have to follow the letter.
Okay, cool. All right, great. Well, good discussion.
Member Crofton.
I had one final thing. Much as I would like to take the interpretation that we have to go by the spirit of the law, we really do have to go by the letter of the law. And I don't see, unfortunately, that non-charter committees are bound by these rules. And I hope that we get this in the ordinance and the ordinance passes.
Okay. At this time,
Yeah,
the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. Mr. Lee, Mr. Hartz. Mr. Hartz, do you wish to make any concluding or rebutting remarks? You have 3 minutes.
I know we're discussing the spirit of the law, and I truly, when I read I didn't read the second opinion from the deputy city attorney. I expected this to be discussed, and I really did feel it was an important issue, especially being some of the conversation that has been had tonight and the fact that you're proposing amending it to make it very clear that it is. My position is, if they weren't taking minutes at all, then for me to ask to put a comment into the minutes would be kind of ridiculous. But if they are taking minutes, then they have put themselves in a position where they have to now, I think, follow the same rules that are applied. If they had simply said, we don't keep minutes, just as they said, I accepted gracefully when they said, we don't audio record, I said, well, if you don't, then I obviously can't get it. But if you take minutes, I think you buy into the fact that there's a certain way of doing it and you need to follow those rules. You don't buy in. And again, this is down to parsing again. It's, are they now not only allowed to parse which sections of the law they can apply, they can even go down into particular subportions of the law and say, well, we'll go by this one because we like that, and we like that, we like that, but we don't like doing this. So we are not an enumerated body in the charter, and ergo, we can kind of pick and choose what we want to apply. Very strictly, I say, hey, they keep minutes. The minutes are a characterization of the public comment. They have no problem in doing those, putting them in their official minutes, and I have copies of those that I got from them today. And I think that for them to then say, well, yeah, but stop, when it comes down to actually giving the person an opportunity to have their impact on the minutes, to reflect what they really said, then no, we don't feel they should be able to do that. In other words, you can't have it both ways. You can't argue one way that we don't have to take them. Well, if you don't have to take them, then don't take them. But if you do take them, then follow the rules. And I think Mr. Wolf had a question. And it was for me, or.
And I don't know where we are, whether I can ask a question.
Conclude your remarks, please, and then if there are questions, we'll take them.
Again, I just want to say I appreciate the fact that you've taken the time to have this discussion and to really parse it out, because I think it is an important thing, and it does give people access to not only the individual policy body, but to anybody who might care to research that policy body by reading their minutes and agendas and things. And those do serve other purposes than simply the legal record.
Thank you. Member Williams.
I just want to say, I understand both ways, and I can see both ways what they're saying, but if you have been taking minutes, just like we take minutes, you live and learn. I didn't know we wasn't under the charter. So this is an eye-opener for me. So as Mr. Lee was saying, we have to go by the letter of the law, but I don't feel good about it, because if they're saying the renters in San Francisco, that's what Bundes is what's here is renters, and it's a well-established board. And for them not to take minutes and to be up under the charter, I didn't even know that. I thought they were enumerated in the charter. I really did. And I really didn't know that we were not enumerated in the charter. So I've learned something tonight that I could take away.
Member Wolf?
Okay, Mr. Hartz. Have you ever seen minutes from the rent board where public comment was reflected?
No, but I've only.
You haven't seen any?
No.
Okay. In the minutes in question, have you seen a draft or the final approved version?
I viewed what was on the website. None of those were the actual minutes because none of them had public comment, but I did today get copies of the January, February, March, and April minutes.
And is there any public comment in those minutes?
No.
Not even in the one in the meeting that you went to?
No, because they refused to put it in.
Okay, so it's not, could you say that it's not a regular practice of theirs to include public comment?
I can't say that it is.
You have five sets of minutes.
Four.
You have 4 sets of minutes. There's no public comment in any of
No,
them.
no. There's public comment in every one, but it is summarized by them. But there is no statement from an individual with their own comment, reflecting their own comment.
Oh, so there is a recording. There is a paraphrasing of public
Yes.
comment in there.
In every one of them, there is a paraphrasing of public comment.
Oh, okay. That changes my answer. Okay, so thank you very much. The reason why I asked the question is because I'm trying to find out if they do have a regular practice of doing that, and it was Mr. Hart's aggrieved, or was there some discrimination for his comments not to be included? That's my question, and I'm wondering. I don't have enough necessarily information. I'm wondering maybe somebody from the complaint committee can enlighten.
Well, no,
Member Knebber?
It's not from the complaint committee, but from what I understand, the idea is if your statement is over 150 words, they can do a summary. What they do is a summary of what people said. They don't do exactly their statements. That's what they do for everybody. Right. And his complaint is, as rightly, boards enumerated in the charter, you have to have that statement in there if it's over, in their words, a brief summary of what they have to say. So it's not been their practice. They haven't been doing it. I don't think he's not claiming that he's been especially put off by them. It's just not their practice of doing it.
Okay.
Is there a motion? Member Knebber.
I move we find no violation.
Is there a second? Moved and seconded. Is there public comment on the motion?
Hi, Kimo Crossman. I am against that motion. As I mentioned earlier, I'm concerned that the tone I'm starting to hear on the task force, in which the spirit of the ordinance is not being acknowledged and followed. The spirit. Let me point you to the preamble of the Sunshine Ordinance. New approaches to government constantly offer public officials additional ways to hide the making of public policy from the public. That's 67.1C. Only 67.1CD. Only in rare and unusual circumstances does a public benefit from allowing the business of government to be conducted in secret, and those circumstances should be carefully and narrowly defined to prevent public officials from abusing their authority. Public officials who attempt to conduct the public's business in secret should be held accountable for their actions. The purpose of the preamble is to give you the spirit of the legislation and how to interpret it. You are here to interpret the letter and the spirit of the ordinance. And what I'm hearing is a lot of discussion about only the letter. Let me point out to you that even the city attorney agrees that it's more than just the letter. How many opinions have we seen from the city attorney, for you people members that have been on for a while, where they invoke the rule of reason? What's the rule of reason in this here? And they'll say, well, the rule of reason, blah, 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 blah. The rule of reason is they already had minutes. The guy submitted them. What was the harm in putting them? And that's another question I have. What's the harm in putting in the statement? There's no harm. It's very easy to do. It's certainly within the spirit of Sunshine, and it's certainly the just thing to do is to allow him to have those in there. And the preamble tells you how to interpret the ordinance. I think all those argue strongly that this should be allowed and encouraged. And where you have to split hairs, then you have to come down on the side of the public. You're here to advocate for the public, and I'm hearing people advocate for the letter of the law. It reminds me of members that used to be on the task force, like Mr. Pilpel, that found every little comma and period that would excuse departments for failures, and it's discouraging for me to hear it. Let me point out to you that, as Mr. Wolf pointed out, the task force in itself is not a chartered body, but because they've adopted Sunshine in their charter amendments, or in their basically rules of order, they follow Sunshine. It's clear that the Rent Board also has adopted Sunshine. They have it on every agenda they have. They embraced Sunshine. So if they've embraced it, that means they take minutes. Well, they take minutes, and that means they have to follow all the aspects of taking minutes. So I would strongly encourage that you find that they should include the statement he provided.
Thank you. Is there further public comment?
Excuse me, I agree with Kimo's comments and some of the others I had heard regarding the logic of expanding the minutes requirement to include the submission of these written summaries. But in point of fact, if their agendas noted that the process that they were going to follow at their meetings was subject to the Sunshine Ordinance, then I think that they have tacitly committed to do that in terms of how they report the proceedings of those meetings. I should also point out that this body is not a body enumerated in the charter. And yet there are provisions within the ordinance itself that only apply to charter boards and commissions. Well, in your bylaws, when it comes to an area where you think you should be covered, but because you're not described specifically in the charter, you say, we adopt the position that's in the law with regard to that. And the Ethics Commission, which itself has never recognized the authority of this body, in its bylaws says it will comply with the Sunshine Ordinance. So I think if you put together the notion that you have a body that it's taking minutes, it announces it's going to follow the ordinance, then let it follow the ordinance. And the minutes should accurately reflect what took place, because they don't audio record it, and so the memories aren't all that dependable. Thank you.
Thank you. Is there further public comment?
Good evening, Commissioners, President. I agree with the last two speakers, and I support the complainant. This brings me back to a speeding ticket I once got. The sign was posted 25, and I was doing 35, and I got a ticket. So I went to court, and I told the judges that I was keeping up with the flow of the traffic. And he looked at the ticket, and he says, oh, yeah, that street, everyone goes 35. They're dismissed. So you people are the judges, so you have the right to do what you want in this case. Thank you.
Thank you. Is there further public, public comment?
Ellen Sang, I agree with the speakers. I just have this one question. If you take minutes, you have to follow the rules. Just like you get a credit report. If you don't agree, the law allows you to say, I disagree, and then you have certain words you can put in your credit report, even though you cannot control what they put into your credit report. I think for the same principle of law, I think that people disagree what you summarize the statement. You should give them the chance to say, I disagree with you, that's my statement. Thank you.
Thank you. Is there further public comment? Seeing none, public comment is closed. Before we take a vote on this, I do have one comment I would like to make. Mr. Lee, although I think that I intend to vote for the motion. However, there is nothing in law or in technology to prevent your doing the kinds of things that Mr. Hartz is suggesting, that you include those bodies of comment in the minutes of your meetings. There is nothing to prevent, technologically or in law, there is nothing to prevent you're recording the rent board's meetings. Go down to a retailer. You can get a digital recording device for $20-30, and it'll take 8 to 10 hours of proceeding. There's nothing to prevent that. And in the spirit of sunshine, I would strongly encourage the rent board to do those things. Is there any further comment? Member Johnson.
Is it inappropriate for me to ask a question of the gentleman from the rent board?
No.
Could I ask you a question?
Please approach Mr. Lee.
I'm sorry, I forgot your name.
Tim Lee.
I'm sorry. Is it true that the rent board puts the Sunshine Ordinance language on its agendas?
Yes, we agree with the Sunshine Ordinance. We comply with the Sunshine Ordinance. What he's asking us to do is to go beyond the requirements of the Sunshine Ordinance.
Don't you feel that the people who receive the agenda then are under the impression that they get to use the Sunshine Ordinance? I mean, by putting it on there, you're implying that that is their right.
They can use the Sunshine Ordinance. It's not the rent board picking and choosing what parts of the Sunshine Ordinance will comply with. It's the Sunshine Ordinance that says what parts we have to comply with.
My question is really just that that's your interpretation, but with that Sunshine Ordinance language on your agenda, it really seems that you're giving the impression to the people who attend that they can follow those rules. So that I would be, the letter of the law does kind of seem like you didn't violate it, yet you're implying to the general public that they can follow those rules. So I wouldn't support the motion. But thank you.
Member Knebber?
Yeah, again, I don't think what the rent board is doing is correct, but I do follow their logic in saying that we are following the sunshine. We put the Sunshine Ordinance on our agendas because we're following the sunshine. And what they're arguing is that the Sunshine Ordinance, that specific section, says that they don't need to do these things with the minutes. So, I mean, this is kind of an argument back and forth. It's just, and I understand the sentiment. Believe me, I'm actually not very happy about it, but I still think that we have to find no violation.
Roll call, please.
On the motion, Member Snyder?
Could you repeat the motion?
Motion is to find no violation.
Okay.
Yes.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Washburn?
No.
Washburn, no. Member Knebber?
Aye.
Knebber, aye. Member Wolf? No. Wolf, no. Member Johnson?
No.
Johnson, no. Member Williams? Williams, no. Member Nee?
Aye.
Nee, aye. Mr. Chair, there are 4 ayes and 4 noes.
Is there a motion to find a violation?
I move to find violation.
And which section? The violation cited in the complaint is 67.16.
Yes, that's right. 6760.
Is there a second?
Second.
Discussion? Okay, because we have already had public comment on this item, I'm going to dispense with it. Roll call, please.
On the motion, Member Snyder?
No.
Snyder, no. Member Cawthon?
No.
Cawthon, no. Member Washburn?
Yes.
Washburn, yes. Member Knebber? No. Knebber, no. Member Wolf? Yes. Wolf, yes. Member Johnson?
Yes.
Johnson, yes. Member Williams?
Yes.
Williams, yes. Member Nee?
No.
Mr. Chair, we have 4 noes and 4 ayes.
The motion fails. That concludes the item. Mr. Clerk, the task force previously agreed to move items number 21 and 22 up to precede item 20. Could you read item 21, please?
Item 21 is the report from the Complaint Committee.
Okay. Is there anybody from the Complaint Committee here? Member Knebber.
At the last complaint committee, we saw 4 items: Crawford versus the city attorney, the Tesh versus the Arts Committee, Harts versus the Rent Board, Harts versus Rent Board, and another item where we found no jurisdiction. His complaint was to the Rent Board, but it had nothing to do with Sunshine. So we advised him to find help elsewhere.
Okay.
That concludes my report.
Okay. Is there any public comment on the complaint committee report? Seeing none. Next item, please.
Next item is the report from the Education, Outreach, and Training Committee.
Okay.
Hanley Chan asked me to make the report. In addition to our usual plans to do articles for other publications and do outreach to community groups to explain the Sunshine Ordinance, we devoted most of our meeting to the project we've been engaged in since March. We want to have a program of Sunshine Awards. We think it would one of our missions is to make recommendations for promotion and outreach, and we think this would be a wonderful way to engage the community and get a lot of publicity for Sunshine. We started the nominations, and there was a nomination for Leland Yee, but we certainly can continue the nominations. One of the things that we would like is for the full task force to become engaged in this and discuss the issue. We brought it up first in March, and we had a press release all ready to go. And Vice Chair Craven said we should put it on the April agenda, which I was heartily in favor of. I was at that time chair of the committee. But it did not get on the agenda. In any event, we had our Education and Outreach Committee in May, and we voted unanimously, and Member Nee came. We had invited him to come, and Member Nee does not like the idea. We had invited him to come and discuss his issues with us. But we did vote unanimously to ask Member Nee to put the item on the agenda so that the whole task force could talk about it. There are basically two issues. One, have a Sunshine Award for someone who's really a good exponent of Sunshine. And then there was also a request that we have what we called an Eclipse Award for people who don't observe Sunshine. There was some negativity about that among the task force, but generally among the task force there was a lot of enthusiasm, except, as I said, for the chair. So at this point, Marjorie wants to talk also about this, but I think it would be great if we could hear from Member Hanley Chan and Member Suzanne Monet, and from all the rest of you as to what you think. And our bylaws do require that the agenda is set with with input from the task force. So I would just bring forward to you our motion, our unanimous motion that the Sunshine Awards go on the June agenda of this task force so that it can be discussed. Marjorie?
I just wanted to say that the Education and Outreach and Training Committee is really enthusiastic, and when we go out to do training, all of us are upbeat, and we really put our heart in it. And when we leave there, people expect something from us, and we just thought, we believe that if you gave them some type of token or something, just a remembrance, and not putting any department down or anything like that, it would enhance people to come. That's why I was so glad to see the young man come out here today, because at one time nobody wanted to come, especially people of color. But when you go out and people start believing you, they start coming back, and that's what we're trying to do, bring people back to Sunshine and tell them that we're really committed to them, that none of us are getting paid, and all of us here is committed. And for the two new members, I really appreciate it. I like your spirit. I go by spirits, and I like your feeling. I like it, and I want to just say that I really enjoyed your input. And another thing that I want to say, I really didn't understand since I've been going to the trial. Doyle is no longer with us, and Hanley has to leave all the time because we know because of his work. And how could he be chair of this committee? He will never be able to give a report. How can he be chair? So
I will.
I think you need to rethink that, sir.
And I wanted to say, just conclude, In the spirit of sunshine, I really do ask that we have the Education and Outreach Committee, have an opportunity to really pitch this idea to everybody and discuss the pros and cons. So I would urge this body to support a position on the June agenda for the Sunshine Awards.
What I would suggest, Member Cawthon, is that the Education, Outreach, and Training Committee bring forth a specific motion, specific recommendation that the task force can then vote on.
We came in March with a specific recommendation, and there was no objection. And Member Craven, Vice Chair Craven, suggested it be on the April agenda, which I enthusiastically supported. However, it didn't get on the April agenda. The motion is that in the spirit of sunshine, this body discuss our plan for Sunshine Awards at the June meeting.
Okay.
And I need a second. Need a second.
Okay. That's the motion to that effect is not necessary. The chair will instruct the clerk to put this as an item for the June meeting agenda. Okay. Again, there are a number of reasons that I oppose doing that, but we can discuss it at that time. Is there public comment on the Education, Outreach, and Training Committee report?
Ray Hartson. There's an old adage, you don't have to be doing badly to do better. When I come before you and point out areas where you're not doing what I think you should do, it isn't with the intention to make anybody look bad or feel bad or anything. It is done with the firm belief that you cannot enforce rules on someone else if you don't follow them yourself. It goes to credibility. And if the very first thing someone can do when you ask them to do something or issue a determination telling them to do something is they can point back at you and say, yeah, but you don't do it. It goes a lot to discredit not only the determination itself, but the whole process. And I really do think that when going out and making presentations as EOT to the community, it shouldn't be a pristine, we have this wonderful law that is just so perfect and has no problems, and if you want something, we'll get it for you and we'll be on your side. We all know it has some flaws, and we all know it has areas that it needs improvement. And I think that in addition to going out and saying, we have this law and here's the things that it can do for you, saying at the same time, but there are some weaknesses we've identified. And as a group, we might come to you in the future to ask for your support in getting those changes onto the ballot by writing to your supervisor or your group representing yourselves and saying, we've heard from the task force. We think the Sunshine Ordinance is an excellent thing. They've said that there are some needed improvements, and we strongly support them because we see what they do, we see the value in what they do, and we want to give them the support they need. Two ways to get this on the ballot. One is to get the supervisors to buy into it. And bottom line, nobody in city government really wants Sunshine to work well because they all have something that might come out. So the reality is it may turn out to be, if you really want to get the sunshine you're dreaming of, going through the voters may be the only way. And if that's the case, when you go out, present a clear picture. There are things this law can do, but there are certain things it cannot do. We're trying to make some changes, and if you really want to see it good, back us up.
Thank you. Further public comment on the EOT committee report.
Kim Crossman, I actually agree with a lot of Mr. Hart said. I think there's a tendency by some of the members on the EOT committee to say, "Oh, Sunshine's this wonderful thing, and here's a brochure, and you can use this to get your information, and rah rah rah, and and by the way, we're advocating for people that have been, departments that have done well, and everyone put in your applications to advocate for the best department." All that, and I'm not sure that it's being used I think there might be other motives for all that, but I won't go into that. But nonetheless, let me just say that I think it is important to more accurately reflect the real challenges that are currently in effect with Sunshine, and to if EOTs want to go out and educate, then they should be educating about how we need to change the current ordinance more so than just what's happening today, because it's not working so great.
Thank you. Further public comment? Seeing none, public comment is closed. Member Williams.
Yes, and Mr. Grossman, I just want to say, when we go out and do education and training, we don't go out with a fan and band. We don't go out that way. We go out and we tell the truth, and we submit the people. If they have the complaint, we invite them to come in and to know their rights up under the sunshine. So we don't go out as a perfect, because we are not perfect, because we all sit up here and know we are not perfect. So that's not what we do. We go out and do real training, because it's our credibility and integrity that's on the line. So that's not how we present ourselves. We let them know that they have a right to come here and submit a complaint. So that's what we do.
Okay. The next item is item number 20. I don't think there's going to be time for it. What I'd like to do is conduct a poll of the members right now to see if they can attend a special meeting next Tuesday at 5 p.m. Member Cawthon? Member Williams? Can you attend a meeting next Tuesday? Member Washburn?
Yes, I can come.
Member Wolf?
Yeah, I'll make it.
Member Snyder?
Actually, I'm not sure. I would have to get back to you on that.
Member Johnson? Member Knebber? So we have...
No,
It's 5 right now.
Sue.
Member Williams, can you attend a meeting next Tuesday?
I really can't tell you, because the prosecutor called the judge. And the
Okay,
judge
Member
called.
Cawthon?
Is it at 5?
It would be at 5.
Okay.
All right, it looks like we would have a quorum.
I would, Mr. Chair, I would just like to request, if possible, if we can get some sort of track changes document, so I don't have to carry 6 versions of previous agendas, previous amendments, so I can keep track of where we are.
Mr. Rustum?
At least electronically.
Mr. Chair, I won't promise you, but I'll try my best.
Okay, thank you. The chair will then send out an announcement of a special meeting next Tuesday. That would be June 1st. That takes us to the administrator's report.
Mr. Chair, we have 5 new complaints for next month, and that's about it we have right now.
Okay. Any questions for the administrator? Is there any public comment on the administrator's report?
Kim Crossman, I've often advocated, and I will continue to advocate, that the task force review the performance of the administrator. There have been some concerns that have been raised by the public and task force members, and I would think it serves the public to make sure that they're being best served. So I would continue to advocate that the task force review the performance of the city staff, both Mr. Threet and Mr. Rustum, that work for you. Thank you.
Thank you.
Ray Hartson, just a quick comment. Last year, I put in a immediate disclosure request for the records of Ernie Lorente, your city attorney at that time, or deputy city attorney. And my analysis of those records, when I did receive them, showed that he spent 6 hours per week on task force issues. And, you know, given that the amount of work that you all have to do and the timeliness of the work and things like that, I think that's way, way below any acceptable value. I think a similar analysis on the time that Mr. Rustum is given to do the job would be only fair to him, because it in many cases may be that the clerk of the board is simply assigning him to other duties and he does not have the physical time to carry out things in the way that they're supposed to be done. And so I think it would be unfair not to do an analysis to determine whether or not that might be the issue rather than any fault of his. And at the same time, the old expression, you don't have to be doing badly to do better. when I analyze something and it comes down clearly that what we discover is that, yeah, you've got plenty of time and it's just the work's not getting done, then we know what we're dealing with.
Thank you. Is there further public comment on the administrator's report? Seeing none, public comment is closed. The chair will entertain a motion.
I have an announcement.
We do have an announcement.
One
Member
announcement.
Wool.
I just want to welcome all the new members to your inoculation and hazing of the Sunshine Ordinance Task Force. This was kind of almost a marathon meeting. Another probably hour and a half, and it really, truly would be a marathon meeting. But I just want to, I think we have a great board moving forward, a task force here. And, obviously we're all open to each other to ask questions or commiserate with or go out and have a drink with if needed be. Okay, thank you very much.
Okay. Member Knebber.
I move we adjourn.
Adjourned.
Nick is still with us.